that. We had a very busy and hectic week. But I hope all is well. How is class going?
Well, let me speak on my part. I think we are doing okay. We are just doing well.
That's nice. Project work, how are they coming about?
Well, we are trying. I mean, we don't have much time. Trying to juggle between classes and the little time and project work. Hey, it's a little bit too much, but
Yeah, it happens. It happens. The secret with project work, don't let it go to the last weeks. Try and maybe complete it as early as possible. And then, as I repeat what I said and what my colleagues said from the first meetings we had, always do what the lecturer wants. Just listen to the lecturer, whatever that lecturer wants. Even if you think that answer is wrong, these are the people who will be marking your papers in the end. And they are the same people who will award you marks. So do exactly as they say. And if you do that, you are assured of passing your project work. And to give an example, there were some differing opinions between some probate. I didn't like law of succession that much, but during classes, there was some disagreements on certain areas of succession law. So Mrs. Ruto's class had, Mrs. Ruto had one particular view, Anastasia had another particular different view. So the secret was try to do as much as the lecturers want you to do, and then you'll hack it. Like, there's some lecturers who are very particular. Well, for example, Leibuta is very particular on how you should draft those documents. I don't know if he has given you the project work and he's told you to keep to write a maximum of 4 pages, and you stick to the 4 pages. If it's a maximum of 5, you stick to it. Don't go anything past that, even a sentence. Just stick exactly to what he said. Now, I don't know if it makes sense. Yes?
On the same breath, I think I'm still confused in regards to Section 3.5 of Law Succession Act. Could you please clarify on the same?
Okay, let me see if one of my colleagues. To be honest, probate is not one of my good areas at all, completely. Yeah. I don't even know how.
Can somebody who you have cohabited with be regarded as a wife for the purpose of succession?
Purpose of succession. The answer is yes, and even judgments have said for purposes of succession, they can be recognized as a wife.
But you have not to prove qualitative and quantitative issues.
Exactly. Yeah.
Because succession. There was a recent case that was decided in Nakuru by Joel. So I was, yeah.
Yes.
And he was saying that even if you have cohabited for so long, even if you have kids, because I think the petitioner had 5 kids with the deceased, and they had even bought property together, but he still did not regard her as a wife.
Solonka.
Okay, Lavin's gone. I'll really be honest. I don't even know how I got 83 in probate, but during the last year, it's one of the units I didn't really resonate with. Maybe Lavin's could assist on that. But from my reading, and from the judgments I've seen, I don't the latest one by Justice Joel Ngugi. I'll have to check it because I think it was he rendered the judgment a few days ago. But there was a judgment before we did our exams, like from Kajiado, and this is the problem with our high courts. A high court in Kajiado says a totally different thing from a high court in Embu, Meru, and so forth. Yeah, but I'm not sure about Justice Ngugi's decision. But from Kajiado, they had held that this thing, what's it called? That, for purposes of succession, they can be considered. But I'll let my colleagues weigh in on that. Maybe Lavins, could you weigh in on that issue?
Oh, well, thank you. Greetings, everyone. We thank God for being here today. Yeah, same. Had an extra chaotic week. I'm still whole, and we're here to do what we've been doing, to assist you guys, and you can call it a day. So, on purposes of Section 3.5 of the Law of Succession Act, who is a woman under this particular provision. You see, the rule of the thumb is anyone who was married under statutory law. And in statutory law, you have different types of marriages. So, but for this purpose, I take Christian marriages, okay? So this is a monogamous marriage. So anyone who was married under statute law and ends up contracting another statutory marriage, is liable for, criminal offense. In other words, what I'm trying to say is a person who was married under Christian law or under statutory law is precluded, from entering into a contractual marriage with another person. However, anyone who was still married under statutory law and marries under customary law, and that marriage under customary law has been done in accordance with the customs and traditions of that particular, could be a tribe. Then, for the purposes of succession, in case the first wife under statutory marriage is not in this place, either administrator of the estate, then this second wife who was married under customary law will be entitled to be an administrator of the estate of the deceased. So the rule of the thumb is you marry under Christian law, okay, and then you want to enter into a marriage again into another statutory marriage, then the law doesn't allow that. So for cohabitation in real sense, I'd say, because we were taught by Mrs. Ruto, cohabitation does not exist. Well, that's it. That's what we were taught by Mrs. Ruto. So whenever we were doing our project work, that's what we were relying on. For the other class that was being taught by Mrs. Anastasia, the class was being taught that cohabitation really exists. So you see there's a conflict between these two lecturers. But for the purposes of passing a project work, you do as that particular lecturer of your choice, says. So for cohabitation in a setup where you have, a polygamous household, the first wife was married under statute law. The second wife was married under customary law. And now this third wife, quote unquote wife, cohabited with the deceased. So it comes to a scenario whereby the deceased estate has to be administered. So the question should be, is this third wife who was cohabiting with the deceased, is she entitled, for succession? Okay. So the answer will basically be no, but her children under Article 53 of the Constitution of Kenya 2010 will be entitled to inherit. So this third wife, okay, under who was cohabiting with the deceased, you see, doesn't fit the description under Section 3(5) of the Law of Succession Act. So when you look at the case of Peter Hinga versus Mary Wanjiku, I think that is the case, and you look at the dictum of was it Justice Mustafa or Justice Miller? I sent that case in the list of cases I forwarded to your respective or subgroups. Peter Hinga versus Mary Wanjiku. I believe so. There is such a case there. And then you also look at the case of Ruenji, okay? And then the recent case of re-estate of Toe. Toe is, I think that was initial TOO, in re-estate of Toe. So I think the Court of Appeal sort of, gave a woman who was married under customary law, to be considered a wife or a former wife in accordance with Section 3 and 5, okay, of the law, 3(5), sorry, of the Law of Succession Act. So the bottom line is, who is your lecturer? What did she teach you on this particular issue? But in a setup, in a polygamous setup, first wife, second wife, and third wife is a cohabitee. So for the purposes of succession, it ends with the second wife, okay? So the catch here is this particular marriage under customary law has to be done in accordance with the customs. And the elements of customary marriage. Was there dowry? Okay. was there consent? And in consent, I will talk about Magiro versus Mumbi. This particular case, the wife-to-be did not consent to be married, okay? So you see, it has eroded already one of the elements of customary law marriage. So in as much as you have a second wife who was married under customary law, you have to ensure that did this marriage fit the traditions, the precepts, and the principles of customary law marriage, regardless if the first wife was married under statute. So I'd say cohabitation, it exists and it doesn't exist. I think it all boils down to the discretion of a judge when handling a particular matter. And of course, the elements of cohabitation. What qualifies one to be considered a cohabitee? One, there's longevity, okay? How long did she live with the deceased? Two, there's the aspect of what did the neighbors say, okay? You people call it mushane. I mean, what did the neighbors say? I mean, how did the neighbors perceive or view this particular woman, okay? And the other element is children. But in law, you're a lawyer, so you'll call them issues, okay? Yeah. So were there any issues that arose, or was this particular marriage consummated? Okay. I think that's the right word to use. Yeah, so cohabitation exists and it doesn't exist. But in the scenario, I think I saw your project work, and that's the kind of question you're trying to ask. Yeah, so that's the position I'll take. So the person who is supposed to apply for grant of letters of administration with the will annexed, you see that different types of grants. So this person is supposed to apply for the grant of letters of administration with the will annexed will be the second wife, married under the customary law, okay? Because the first wife, I think she was indisposed or she was out of the jurisdiction. There is something like that. But the cohabitee is not entitled to this. But her children, for the purposes of inheritance under Article 53 of the Constitution, they will do that. So yeah, so long I think that's what I say.
Patrick Lavins, but I feel like the third wife had met the prerequisite for cohabitation. There was issues, there were kids, they had stayed together for close to 17 years. So don't you think it's at the discretion of a judge? Can I take both positions?
No. The wife, I mean, that cohabitee, she can't be an administrator of that particular estate ahead of the second wife.
That I'm in agreement with.
Sorry?
That I'm in agreement with, but can she be regarded as a wife for the purposes of succession?
I'll still say no. That's the answer I'd stick with.
Okay.
She can't, I mean, she doesn't fit the bill in accordance with Section 3(5). You see, by the way, what you people don't know, there is an amendment bill, okay, to the Law of Succession Act. I think it was sponsored by the Homa Bay Town Member of Parliament, Honorable Peter Kaluma. So I think what you're trying to raise, purity, is being addressed in that particular bill. Okay, so it sort of sorts that problem whereby someone dies and the next day you see there's someone showing up with a kid, saying like, what, I was cohabiting with the deceased. I mean, he fathered my child. Okay, so this particular issue that you're trying to raise has been addressed in that Law of Succession Amendment Bill of 2020, I presume. I'll keep you guys updated on the progress of the bill. I think right now it's in the, is it second reading or something? The Senate had their session the other day on Friday, but the National Assembly currently, as we speak, is still on a recess. So I think they're supposed to resume on 21st this month. Yeah, so I will keep you posted. But those are the issues that are about to be solved through that particular bill. Yeah, so for that third wife, no. On paper, yes, but when it comes to the succession, I'm afraid they may not be regarded as a wife.
All right, thank you.
Awesome. Solonka.
Karibu-san. Yeah, that was the debate that usually went on every now and then when we were in class. I never contributed to it because I didn't even know what people are talking about in the first place. But yeah, that's it. And then don't focus so much on section 3.5 because that's just one bit, and there is an entirely wide area of what there's an entire wide area in succession law. Like for example, in our during our exams, nothing came pertaining to section 3.5. So that's it. I can see who else is in the meeting other than Lavince and I. Who else? One of the colleagues who's in the meeting. And I can see Muturi has a question. Muturi, go on.
Thank you, Mr. Solonka. Maybe to do a follow-up on that debate and what Purity was asking, like Mr. Is it Patrick has said, we should, when answering question, especially project work, we should be guided by the lecturer gives.
Exactly what the lecturer said.
Yes, we are taught by Mr. Odera, and he believes that marriage by cohabitation do exist as long as you can prove there is that long period of cohabitation, and you can prove reputation, that is the members or the member of the society viewed you as a husband and wife. But now when it comes to the project question, we only taught that they had children, and they lived, I think, for around 7 years together. The cohabitation lasted for 7 years, but we are not told about what the members of the society used to view them, whether they viewed them as a husband and wife. So for me, I feel like in this scenario, you should leave, when answering the question, you should leave it open-ended in such a way that you will say that if at all she can prove that the members of the society used to view them as a husband and wife, then she will qualify as a wife. But if that is not the case, then she cannot benefit under the estate. Thank you.
Yeah, that's true.
That clarification is good. I really appreciate. Thank you.
Karibu sana. So you seeing the way these things are differing. Oh, Ms. Ruto is saying one thing, or the other lecturer is saying another thing. Just go with what the lecturer is saying, because just make them happy. Then yeah. So Arunga and then Ochieng Otieno.
Good evening.
Good evening, Arunga.
Yeah, I just want to let me read 2 paragraphs of that ruling by Justice Joel Ngugi. I'll read paragraph 39. In any event, based on the evidence on record, I will have concluded that there is little qualitative and quantitative evidence to warrant a presumption of marriage in this case. Paragraph 40. The conclusion then is that C was not a wife of the deceased for purposes of Law of Succession Act and cannot be a beneficiary to his estate. To me, in my view, what I'm getting from what Justice Ngugi was saying is that if this petitioner had managed to prove a presumption of marriage, then for purposes of succession, then this woman will have been considered as a wife for purposes of succession, which in my view, I think is in line with what Madam Anastasia usually says when interpreting section 3 subsection 5. Yeah, thank you.
Thank you so much for that. Like, yeah, that's a good reasoning. It's a good judgment. One of the judges that I respect most is Justice Ngugi. So, yeah, thank you for that. Thank you for that. What about you, Ochieng? Ochieng, I can see your hand is up.
Okay, thank you so long. I don't know why. I have been in Anastasia's class, and I remember the last time I asked you if I could see the project work of Sasha, you directed me to Alex. I don't know if Alex is here. So, but
Alex, let me see.
The questions which were set in the last project are more or less similar with the ones which are set in this current project. In our project, we have 4, I think, people that we are to discuss if the wife or not. But the first three, I think the first 2, and then we have a cohabitee and then a girlfriend. So in matters of section 3.5, Anastasia has been very clear that we don't apply in matters of cohabitee. Anastasia has been very clear that we don't apply 3.5. You know, I don't know why people misquote her, but the thing is, if you want to quote 3.5, 3.5 only applies for those who are to prove customary marriage. If you are to determine if a person is a wife for the purpose of succession and that person is a cohabitee, and as such as says, then you go to common law and you check the Evidence Act, section I think 118, where we check the presumption of marriage. And if you find the qualitative and the quantitative elements are filled, then that person is a wife for the purposes of succession. He doesn't prove or she doesn't make a cohabitee a wife via section 3.5. It doesn't work by 3.5. 3.5 is only for the second wife who is married under customary law and has been proved, or we have proved that that woman was married according to that custom. If you get a cohabitee, you go to Evidence Act and Judicature Act, which allow us to use the common law and then check the Hortensia's elements. So that's how Anastasia put it clear. And if you are to do it for Anastasia, then I will differ with the Patrick's view. I think that's my submission.
Yeah, actually, what you're saying is true. What you're saying, if you're doing it and using Anastasia's way, you have to follow what she's saying in class. But if you're doing it, if your project work is being marked by Mrs. Ruto, you have to follow what Mrs. Ruto is saying in class. If your project work is being marked by a different lecturer who's saying a different thing, then you have to follow what that lecturer is saying. You see, Patrick is coming from the viewpoint of what he was taught in class. We were in the same class, and that is what Ruto told us in class. Personally, I wasn't contributing much on it during class and all, but that's what happened, and that's how guys in our firm even did our work. You say that they are more or less similar, yeah? And guys from Ruto's classes who did what Ruto said passed. From Anastasia's class who did what Anastasia said passed. Those who didn't do what she said actually failed. I think Anastasia was one of the lecturers who was giving, I think, 10, 11. She wasn't giving very high marks, so you have to be extremely particular with what she says. That's the best advice I can give on that issue.
Solanka.
Yeah.
Solanka. Was that guy was talking before you did? Yeah.
Mr. Ochieng.
Sorry.
Mr. Ochieng.
Yeah. Mr. Ochiel or Ochieng. Okay. Counsel. Yes. It all depends with the lecturer who taught you. So for me, I will defend Mrs. Ruto's view to that, okay? Because that's what I was taught. And also from my own, learning, interaction with different, academic materials, I'd still stick with my view. So what I'd ask you people as an assignment to do, go to section 66 of the Law of Succession Act. Read the language and the spirit of that particular provision. The other day when the former AG, the Motishan Githum Wigai, was submitting before the Court of Appeal, he said there are lawyers who will interpret the Constitution in accordance with its spirit, and there are lawyers who will interpret the Constitution in accordance with, just the way it was written. So I still say the spirit of the, of a statute, plays a huge role in understanding and comprehending exactly what, the drafters of this particular law wanted to, send home. So section 66 of the Law of Succession Act, read that act. And then there are quite a number of cases I sent, the Hortensia Wanjiku case, the Peter Hinge case, there's Magiro versus Mumbi, there's Ruenji's case, and then the recent one that I've said, the estate of Toll. Read those cases. I think we will all find, a common place or a common ground where we could, agree on, because that's just it. And who is a spouse? In accordance with the Law of Succession Act, does a girlfriend qualify to be called a spouse? In the untimely or timely death of the, of the testator, the preference in administering that estate, to whom should it go? You start with the girlfriend or you start with the spouse? You see, like I told you, a number of these laws need amendments. So hopefully the Law of Succession Amendment Bill of 2020 will address all these uncertainties, that we have right now. In Magiro, there's a big conflict between the Law of Succession Act
Lavins, you're muted.
Oh, sorry. I was saying, maybe the Law of Succession Amendment Bill will solve the kind of uncertainties that we have. And there's a huge disparity huge conflict, okay, between the Law of Succession Act, the Marriage Act of 2014, and also the Matrimonial Property Act. On this other side, women, are saying they've been discriminated, based on inheritance of the property, which I do agree, okay, because there is a language used in the Law of Succession Act, that is I don't want to say manly, but it locks out, okay, a lot of, women. And even if you look at the Land Act, like all these laws relating to inheritance, and especially in the rural, areas, I've done my research and I've come to understand that we need to harmonize all these laws. So hopefully, the bills in Parliament would address our concerns. But the assignment I've given you, please look at it. If you still have any problem in trying to understand them, you can reach out to me, because now it seems my learned senior Solonka has washed his hands and he doesn't want to get associated with probate. Yeah, so you could reach out to me, and we will find a common ground. Yeah, so that's just it. Yeah, thank you.
Yeah, that's fine. That's true. Probate. Moita Karen, please go on.
Thank you, Mr. Solanka. So we've said that when it comes to the project work, we should stick to what our lecturers say. But since for the bar exam, it's not going to be a lecturer's marking, so which side do we go with?
That's an interesting point, actually. Oh, yeah. So in the bar exams, Lavis, you wanted to give?
No, I'll speak after you.
Okay. In the bar exams, if you have some conflicting positions, just give in brief, just give maybe both sides, and then like just show the examiner, because you see they'll mark your paper, they'll mark everything that you've written there. You could give both sides and say, as a by the way, there are these debates, give your judgments, but just don't give what we call rumors. Try and base it on a specific point of law. So if you're for Lavin's side, give a judgment on it. If you're for Kinawambua or Tien, Runga's side, give your judgment or your case law provisions or any basic legal provisions that you're relying on for it. That will earn you marks and score you points. That's something that will happen. Now, and the thing is, and this is what I say, the exams, they wouldn't bring an entire question. Have you guys seen our probate question paper, the one that was set last year? And not last year, this a few months ago. You find question A, 5 marks, or maybe 5 marks. Question B, 2 marks. Question C, 3 marks. Question D, like the first question has so many subsections in it, and around like 2 marks, 3 marks, 5 marks, and so forth. The questions that carry used maybe 20 marks. The questions that carry the most marks, that will come and they carry the most marks, 10 marks, one particular question, only one question having 10 marks on its own, they are usually drafting questions. Drafting questions have so much marks. So most of your energy need to go to these drafting questions. And the issues of section 3.5, yes, focus on them. It's good for debate. But as I say, there's an entirely large area of law other than section 3.5. Personally, I can attest, I never engaged, Lavins was in my class. Probably it was one of those classes I would just sit down and listen to what people say. And in every class, guys will raise new issues pertaining to section 3.5. Section 3.5. Every day we discuss section 3. So Lavins will confirm that. Section 3.5. I never even knew what that thing in particular. Man, funny thing, I was just shitting my orals, but I had a clue about it. So, and I still got it 3 in probate. So there's an entire wide area in law of succession that you guys need to be reading, drafting, learning how to draft. Before we thought that they could never bring a question on drafting a petition. They did bring 2 questions on drafting petitions in probate. So that's the advice I could give. But in exam settings, if you find a conflicting position, give both sides of the law if it's not settled. Now, for this issue that's being raised on law of succession, you see there are different high court judgments providing for the same. Now, unless somebody moves to the Court of Appeal and we get one judgment from the Court of Appeal, which becomes now binding unless appealed from, then the positions, that's what happens. Let's give both sides and argue for both sides.
Okay, thank you.
Karibu-san.
All right, great. Yeah, so Moita, I wouldn't, omit more or less, from what Pereno has said. You are a scholar, okay? You are a lawyer. And lawyers are people who are learned. So you have to show this particular examiner that you understand both views. It's the reason why we have dissenting judgments, okay? So if you are to do your own research, perhaps for your PhD, okay, and you do research based on the basic structure doctrine or the eternal clauses, okay, you see, you'd give, also that opinion by Justice Fatuma Sichali, okay? That's a dissenting judgment, and it will even contribute much more to your thesis, okay? So when you have an exam setup, you have this, conflicting position on that question, then just give both. And then, don't forget, I think one of the golden rules of legal writing, and drafting, you have to give your opinion at the end of the day. Yes, there's this point of view. Cohabitation exists, reason, blah, blah. Cohabitation doesn't exist, this is the reason. Now, as a scholar, as a bar exam candidate, what's your view on it? You see, that may even add more marks to you. You never know. But it's how, it's about mastering the art of seduction when it comes to marking. So one of the cardinal rules is that, you have to appease, or appeal to the emotions of your, of the examiner, okay? So like when this case comes before me as a judge, I know my position already. So like a good lawyer knows the law, but the best lawyer will always know the judge. So you know exactly I'm not pro cohabitation, okay? So when you come for your submissions, or when you find your submissions, you're like, you know what, PLO doesn't like this, so this is my position and everything. Like you would win me easily. So at the end of the day, you just have to find a balance between those who are pro something and those who are against something, and then you harmonize the two and you give your own view. So that's how you should approach any exam question that is conflicted. And rarely, like Solonga said, rarely will they give you a whole 20-mark question on a question like section 3.5. No, they can't do that because they know even the current jurisprudence isn't developed enough, to like have a common position and say this is the law and that's the law and we can change it. So that's what I think CLE examiners avoid, because they know some students are taught this way, others are taught like this. Yeah, so I hope that helps, Moita.
Yes, it does. Thank you very much.
Awesome. Moreno.
No, okay, no problem. Now we can go on. I don't know how many of the colleagues are. I can only see Lavin and I, but we'll still go on. Now we want, okay, unless there are any questions that you guys want to ask in particular, I will suggest that we proceed. Now go on towards our oral mock-up session. I prepared some questions. I also have some answers. Then you can have an engagement on it. If you need any questions, feel free to raise your hand. If you feel shy, I will also suggest you raise your hand because you'll appear before an oral panel. This is the time to get rid of any fear. And but if you feel extremely shy, you could just type it down on the chat box and I'll read it out. Okay, Gola. Let's start with Ogola. Then, since it's Lavitz and I, will each ask you questions. Yes. How are you?
I'm doing fine. How are you?
I'm well. You prepared?
Before we get to the question, I just wanted a clarification on a particular point. Last week, while we were in the probate class, we were being taught by Mr. Odera, and the issue of who are dependent is came up, and in particular, it was the issue of a divorcee. So the question I asked him, because he taught us that someone who is divorced, if you are divorced and then you already divided the property, if your partner dies, you are not entitled to inheritance from because you are already divorced and you have separate properties. So my question is, for the purposes of Section 29, is a divorcee not considered a dependent? And for instance, you've divorced, but your partner acquires other property. Are you not entitled to inherit from such property just because you are divorced and you already have your separate property? What disqualifies this person as a former wife? What is the disqualification from section?
So he said divorces because even if Nakwaga twins a probate, I can remember very well under Section 29 of the Law of Succession Act, it talks about not only wives but former wives. Yeah.
Yes. Yeah. Sure.
Now, who's a former wife? Who, according to your maybe, how do you understand who's a former wife?
My understanding of a former wife,
yeah,
someone who actually it's someone who is divorced, because those who have separated is not a former wife, that's still a wife.
Exactly.
So divorcee is a former wife.
Okay, now from Section 29, I remember Section 29 of the Law of Succession Act particularly provides for a former wife being a dependent. Yeah. Now, what is the other section of the law? If they are a dependent, is it 29 read together with which other section?
Is
it 66? Amangapi. The Kenya law is not working, it's loading a bit. What other section is that? Because I remember 29 was the one that talked about meaning of a dependent, and former wives are included. But just from that basis, I will presume that yes, they can inherit by virtue of them being a dependent. So maybe the issue will be, are they dependents or not? I will say they're dependents, pursuant to Section 29, from a plain reading of it. Ama, what's your opinion on it? Maybe Lavin, so anybody else can contribute really.
Mr. Solonka, if I may.
Let me try. We had that same discussion in our class, Mrs. Ruto's class, and she was particularly saying that they will go into Section 29 and Section 26. So Section 29, they are a dependent, and then Section 26 will come in that the provision on adequate provision. That is, let's say they divorced with this guy, and then this guy maybe after the divorce got a lot of money, and now the guy is dead. So now the former wife, the divorcee, will come in through Section 26.
Yeah, that's a kind of looking but adequate provision. Those who have not been adequately provided for. Yeah.
Yeah.
Yeah, and then with 20, because 29, if I'm not wrong, my Kenya law is not working, but maybe you could confirm. 29 talks about a former wife, meaning they are dependents.
Yes.
But let's see others. I saw guys, Lavins, you raised your hand, you were talking. Then we can go to the rest.
Can I interject, guys?
Yes, totally fine. Okay. Yeah.
I was with the same thing, and I'm the one who raised the issue with Miss Ruto, but she said that a divorced wife may not necessarily be a defendant, but the children will be. In that, if the court will consider that if when you divorced, were you allocated some property, and if you were, then you cannot be the wife. Now that woman cannot succeed, but the kids can succeed under 53 and under 29. And then she said, currently we have no case, but we have a situation like there's something like that happened where a divorced wife came after a man. I don't remember his name. Maybe Gashira, you can help me. I don't have my books with me. Where the wife, okay, here's the story. A man was married, then he became an MD. He got divorced, became an MD. He married again, he became an MD. Then he died in a road accident, so he didn't leave a will. But now the former wife came and said that even though she was given property, it was not enough. And that the new wife now, because the man has acquired new wealth, she wanted to be allocated some money. She said that the issue was never settled in court, but from what I remember, she said that I don't know, there were provisions where the court can relook at that property and then choose on a way of allocating, but you will not inherit 50-50. For example, she used an example of 100 million, where people are receiving 100 million, but this former wife, that man, by the time she was young, she was worth 100,000. So that divorced wife had received 50. So if this woman wants to challenge that will and she wants to inherit now, let's say 100 million like the rest, she cannot be given 100 million, but she will be given less than 100. Now she will be given less than, more like a half of the percentage that the others were given, if only she can sufficiently prove to have been maintained after that divorce. I don't know if you can have the situation.
Solonka.
Yeah, Levin's gone.
Thanks, Nyabio, for your insights. But what I'd like you learning, friends to know is this. You see, whenever you're talking about a former wife, it doesn't necessarily equate to a divorced wife. You see, a former wife could be, okay, just to begin with, the Law of Succession Act itself, it's a sui generis law. In other words, what I mean, it does not require other external interpretative documents. So there's this case, the High Court of Malindi in the estate of GCB. Please note that case down, note it down. I'll repeat, okay? The High Court of Malindi in the case of in the estate of GCB, who is the deceased. It's a recent case, 2020. It was succession cause number 98 of 2016, but it was decided in 2020 in the estate of GCB, deceased. So the learned judge in this particular case, one of the issue was, what really qualifies one to be termed as a former wife for the purposes of succession. And before I proceed any further, yes, a former wife can be, regarded, a divorced wife can be regarded as a former wife for the purposes of succession. So in this particular case, the judge, in expounding and interpreting the subject of Section 29A, paragraph A, he noted that as it comes out from the provisions, I am only reading this section verbatim, okay? So he said, as it comes out from the provisions in terms of section 29, the definition of a dependent extends to cover former wife or wives. My understanding of the provision is that it enables ex-wife or wives who are under reasonable provisions and support by the deceased prior to his death to be still considered as dependents of the deceased even after the marriage has been dissolved. So the court, having found that even after the dissolution of the marriage, the divorced wife still qualifies as a wife for purposes of succession, proceeded to note that I find, again, I am reading it verbatim, I find that the operative words are such that even after a marriage has been dissolved and the decree absolute issued by the court, there will be a claim under the Matrimonial Causes Act for distribution and sharing of the marital estate. Hence, the canon and rule of interpretation under Section 29 of the Law of Succession Act. End of quote. So, in support of the foregoing position, by this particular Court of Appeal, by the Court of Appeal again in another case, in the estate of Ruben Zioka Mutua. Again, I said this case in that list of cases. Please look at it. So, in support of the foregoing position by the High Court judge at Malindi, the Court of Appeal in the case of the estate of Ruben Zioka Mutua, deceased, probate and administration course number 843 of 1986, the court observed inter alia on the interpretation of the amendment to Section 3 of the LSA then. He said, verbatim, that I have read this particular provision of the amendment carefully, and my conclusion is that Mr. Situma misunderstood them completely. So the amendment the amendment in talks of envisages a situation where, for example, a man whom I will refer to as a married woman B under customary law, and that marriage is valid and recognized under the custom. So you see, this particular case was trying to at least bring to light who a former wife or wives is. And again, the last case of Jane Pamela Anyango Kuna and another versus Jennifer Njoki Uching and another, a 2006 case, the court, although arbiter, it said that, verbatim, I have perused the documents filed by these parties in these objection proceedings, and I am inclined to agree with the first petitioner that the deceased had not divorced her by the time of his death. So in any event, Section 29 of the LSA recognizes former wives of a deceased person, whether or not maintained by him immediately prior to his death, as dependents of the deceased estate. So what you guys have to note is that those three cases, I think, will answer your questions. So the estate of GCB, Jane Pamela Anyango Kun and another versus Jennifer Njoki Uching and another, and then the Court of Appeal case, the estate of Ruben Zioka Mutua, which is sent in that particular list. That's what I'd say about a former wife. Yes, for the purposes of succession, they can inherit.
And actually, with the wording of Section 29, it's whether or not maintained. So you don't even have to prove maintenance. It's whether or not maintained.
Yeah, sure.
So, and just from a plain reading, whether or not maintained, there's a distinction, because the first bit talks about those who are, whether or not maintained, and then there's a second bit under it where you have to show maintenance. So that kind of distinction, even when interpreting, remember, judges don't make the law; they only interpret the law and apply it. Yeah. So in this particular case, my answer will be yes. Divorced wives can claim whether or not they're maintained. That's what I want.
Also, Solunka.
Yeah.
Also, like you see, that specific case of real estate of GCB, that is enough to answer your question. Because even as a wife, it is only fair, if this case offers that answer, that in the issue of dependency, you see, there's always that legitimate expectation that having provided for the household, then the divorcee now, or the divorced wife, should only benefit from the estate of the deceased. So it isn't rocket science. So yeah, I mean, whether maintenance is pleaded or not, they are still entitled. And I think I've answered your questions.
Yeah. Now, Ogola, I've just noted your name down. You'll be the one who will begin because you said wait. So Let's first take Arunga, and you see, if your hand was raised up and you've asked a question, you will answer some questions from us also. So Muturi and Arunga, and then we close off the questions section. Then now we begin the orals. Then in between we'll reopen it. So Muturi, go on. Then Arunga, go on. Then now afterwards we begin our oral mockups. I don't know why today you don't probe it. Go on.
Thank you, Professor Ronka. Maybe I want to comment briefly on former wife, we had also such a debate before, or in Mr. Odera's class, and he was, I think he holds a different opinion from what Mr. Patrick has said, because for him, he said, if, for example, I divorce, I have a wife, and we separate for one reason or the other, God forbid. And then there is no formal, this divorce is not formally terminated by a court order. Then at that time, you'll be regarded as a former wife. And if, for example, there is a decree absolute, that is, we have filed a divorce petition and there is a decree absolute, then what will be considered is whether there is a court order for maintenance of such a former wife. If there is such an order, then you will qualify as a former wife. So he said, as if at all there will be the divorce was fully or completely terminated by a court order, then you are disqualified as a former wife. That was his position.
Thank you, Muturi. Thank you, lecturers. Okay, let's go on to who else? The other in. Who else had his hand up? Arunga.
Yes. Yeah. Well, I want to agree with the Lavin's interpretation and what the courts are saying, that a former wife, for purposes of Section 29, is to be considered. However, in terms of practicality,
you are muted, Arunga. Kindly repeat, kidogo.
Okay. Yeah, I was saying, in terms of Section 29, I want to agree with Lavin's interpretation and what. Sorry. Yeah. So I was saying, I want to agree with what Lavin is saying concerning the interpretation of Section 29 and what the courts are saying. However, in terms of practicality, the question then should be, how many former wives are usually ready to go back, assuming this former wife has gotten married into another relationship? How many of them are usually willing to go back to the home where they left? Then the answer, which and what was the view of Ms. Ruto, is that most of the time these former wives don't usually go back to where they left in order for succession. And equally, when you look at the proposed amendment bill, it wants to do away with the term former wives. Yeah, thank you.
Thank you so much for that. Thank you so much for that.
Sorry, I think Arunga said what I wanted to say. And I will request that you guys maybe take some time to, in case someone is asked this, it can be a challenge. So maybe you can take more time on enlightening us on this section 29, 26, and yes, 29.
That is totally fine. I'll personally go read Succession, even if where I'm working at Fanyi Mingi. I'll do it, and then now we'll interact in the next section. In the next session, anyway, sorry. Now I will start with Ogola Esperance. Are you in? You asked a question just a few minutes ago.
Yes, I am.
Okay, so karibu sana. So we'll begin with you. Now let's start. No, don't worry. My questions are usually very fair. I don't know about Lavin's, but mine are usually very fair. Don't worry.
Okay.
You had it. Now, okay. First question will be: what are the types of injunctions you know?
We have permanent injunctions and temporary injunctions.
Permanent injunctions
and I think temporary injunctions.
Mm-hmm.
Yeah, that's much I can say about that.
Okay, thank you. Okay. Now, my next question will be, what's the difference between review and judicial review?
Let me start with a judicial review. A judicial review is normally done against public bodies or administrative bodies, public or private, where their actions are questioned in court, whether they've acted to traverse the law or that they have acted overboard their role. And a review, on the other hand, is an instance where a case is reintroduced in court, maybe some points of law or points of facts that were missed. So
Okay, thank you. So far, so good. Now, tell me, what is the essence of you being at the Kenya School of Law? What is the essence of the advocates training program? What essence is it to you?
Thank you for that question. Kenya School of Law is, I can equate it to a professional body that refines lawyers to become I count the Kenya School of Law, having done my undergraduate studies, to come and myself with the necessary practical bit of the law. And being after my studies and after doing my bar exam, I'll be able to qualify and practice as an advocate of the High Court of Kenya, because without that qualification, I'll not be able to represent anyone in a court of law.
Okay, thank you very much. Are you familiar with Desmond Peter's case?
Yes, I am familiar with it.
You're familiar with the Desmond?
It's a case about someone who was accused of murder, but the prosecution. The prosecution was let me just compose my. The persons who are represented in the accused found loopholes in the prosecution case about the facts were not added. At the end of the day, this Desmond Peters was released, or was released from prison based on the fact that there were some crucial points that were missed by the prosecution in prosecuting his case.
Okay, now thank you very much for that. Now, since I'm seeing you're very well versed with the facts of Desmond Peters, kindly, and this is my last question, in 2 minutes, please give me the opening statement. Presume that you are the prosecutor in that matter. In 2 minutes, give me the opening statement for Desmond Peters.
Thank you for that question. I cannot really remember the opening statement in that case, but
no need to remember. Just come up with your own opening statement. Just a random. Presume you're the prosecutor in conduct of the matter in Desmond Peters. Kindly make an opening statement for that. Just on your feet right now, in just a minute or so, or two.
Okay, thank you for that. Thank you for that clarification. So, the Honorable Court, Justice, Your Honor, Mr. Justice Pareno, my name is Ogola Timothy, the prosecution in this case. And my Honor, I want to start by saying that this case has taken us time to investigate. And here before you, we want to present facts and law to make our case. And Your Honor, I believe throughout our presentation, we are going to capture your attention to the various points that lead us or will help you to find a fault in the accused. And Your Honor, as the case proceeds, we are going to tie the accused to the scene of crime, and we are really going to prove that this conviction was right by the judgment of the lower court. Thank you, Your Honor.
Thank you, Gola. I appreciate that. A very good attempt. Now I'll hand over to my colleague Patrick Lavins to ask you the questions for the remaining 5 minutes. Then we'll revert back with our comments. Lavins, please go on.
Thank you, my learned colleague. Ogola, how are you?
I'm doing fine, Mr. Lavin.
Right. So, what's the difference between a decree and an order? In one sentence, what is the difference between a decree and an order?
A decree is a final finding by the court, and an order is a finding on a particular point of law that has been raised either by the defendant or the plaintiff.
In 5 words, Ogola, I need you to tell me the procedure or the trial process in 5 words. I don't need you to explain. I just want 1 word for each step. So the 5 stages of a trial process in criminal litigation. Could you kindly?
Thank you, Mr. Lavin. I must say that I'm still green in that area, but I'll find time to go through it and come up with a better word for the trial process. Thank you.
Okay, what's the difference between a judgment? Sorry, what's the difference between judgment and sentencing?
A judgment is delivered after hearing both sides or in a case, while a sentence is in criminal law. A sentence is the final decree by a judge on that is delivered that is directed to the prosecution or the police to either release or not to release, but to keep an accused person in custody or in prison. Thank you.
Okay, and my second last question. Can you hear me?
Okay. Losing you a bit, but
can you hear me?
Yes.
Awesome. So, what's the minimum composition of the Court of Appeal judges?
Sorry?
What's the minimum composition of the Court of Appeal judges?
Okay, the minimum composition of the Court of Appeal judge should be an even number, and there is a minimum. A minimum.
Yes, what's the number?
It's a minimum of 5.
Right. And the last question. Now that today has more or less become a probate and administration day, the last question is based or premised on that. So this is the question. What's the difference between gift inter vivos and donatio mortis causa?
Thank you for that question. Gift inter vivos simply means a gift in contemplation of death. And the other Latin word I seem to lose it, but
donatio mortis causa.
I would seek your guidance on that.
Right. Thank you. And we will give your feedback. So Solonka, I think you should go first.
Okay, thank you for that. Now, for me, my questions were fairly good. You performed them very well. You did very well. Now, on the issue of types of injunctions, you gave 2, but yeah, you could just mention others. Mareva injunction, it's a type of injunction, prohibitory injunction, mandatory injunctions, and so forth. And you see, in that particular type of question, it's actually a very simple question when you asked type of injunctions. You can now try and maybe expound on it so as to bite some few minutes. When they tell you, can you give us some types of injunctions? You can start with, maybe what a permanent injunction is, explain it. What is a Mareva injunction? Yeah, explain it. Arresting of the defendant, attachment of the property. Try and explain it. Give statutory provisions. Order 39. Give order 40. In brief, so as to show the lecturer that you know. So when you're answering questions, try to pair up the law with the answer. So when you ask about injunctions, it's provided for under order 40 of the civil procedure rules, and then you can proceed to expound more on them and list the few you know. And when you asked about injunctions, this classic case, Giela versus Casman Brown. You can listen to it. You cannot listen to it. You can go on ahead and explain what the conditions in Giela versus Casman Brown are. You have to establish a prima facie case. You will suffer irreparable injury that cannot be easily remedied with monetary damages. And the third ground is the fact that the balance of convenience lies with you. You could mention those so as to, you leave the lecturer knowing that, yes, this person knows his stuff. You answered that question very well. You did well. Now, on the issue of an opening statement, there are certain elements that need to be in your opening statement. And Mwaniki, also if you hear Mwaniki is in your panel, Mwaniki or Mosa, maybe we'll get some of those lecturers. I'll try and get some of the names. Make sure you prepare. Just read an opening statement. You can ask your friends to send you opening statements. If you need, I can also send it. I can send the one that I did during class last year. Just have a glimpse, because these are commonly tested question in exams, and lecturers ask this question in particular. So when you have an opening statement, there's some basic things that you need to first grasp. Yeah. First, is this case? Maybe they may not ask about Desmond Peters, but they may give you a fictional case and tell you a particular court. Maybe, it may be a high court or it may be a magistrate's court matter. So you need to distinguish, when do you use your honor and when do you use my lord and all that. There are magistrates and there are judges. So you need to kind of distinguish that. And the opening line in your opening statement, there's no template on it, but first introduce yourself. May it please you, your honor, if it's in the magistrate's court. May it please you, my lord. May it please you, my lady. Yeah? And then you move on forward to the next paragraph. So the first introduction, may it please you. That's the first thing that needs to open. The second bit is you need to do what? You need to introduce yourself before the court. Who are you before the court? So, and if you're the advocate, for instance, for the plaintiff, you introduce yourself and you introduce your other counsel. So, for instance, you can say, my name is Pareno Solonka, and I'm the advocate for the plaintiff in conduct of this matter. My learned counsel, Mr. Patrick Lavins, appears for the for the defendant in this matter. So the second bit is introduction. The second bit is the introductory bit. Now, the other thing that you now need to introduce after introducing yourself is the case theme. Is it the case theme? Yeah, the case theme or something, or the theory. So, for example, in Desmond Peter's case, if I can remember very well, it was something about robbery. You got it very right. So, you can say in one, this is usually a one-worded, like a one particular sentence that sets out what the entire case is about. So, Your Honor, before you is a case of daylight street robbery, etc., etc. So you've already given the theme. Now, the other thing that you need to give is brief facts in a few words, just brief facts, and then the witnesses that you intend to introduce and the evidence that you intend to seek. And then now you close by showing what? By telling the court what you would want at the end. For instance, you can say, we will prove to this court that the only verdict that befits the accused person is the verdict of guilty. And that's how you do opening statement. You just break it down in those areas. Make sure you have an introduction, introduce yourself, have your theme, have a good case theory, and then give some brief facts. After you've given some brief facts, you also need to give a summary of the witnesses. Who will you be calling during trial? And after you're done with that, close it up now. Other than that, you did extremely well. Yes? Yeah, so that's totally it. Now Lavins can give his feedback, and now we'll go to the others. Personally, you did very well on my bit. You'd score very high marks on my end. Give you a 17 out of 20. Thank you. Now Lavins can.
Thank you, Senior. Ogola, sorry. Yeah. My feedback is as follows. So, gift inter vivos and donatio mortis causa. So, gift inter vivos means the transfer of the property becomes operative, okay, during the lifetime of the donor. Whereas, when you talk about donatio mortis causa, it's a gift made in contemplation of the death of the donor. So, and it always passes to the donee after the death of the donor, and then it resembles a gift inter vivos in that it takes effect when the delivery takes place, but it only becomes absolute if the donor dies. So I think you are mix matching the two, but I hope that is clear. And then the other question that I asked you was about the minimum composition of the Court of Appeal judges. Basically, what I wanted to know is under statute, what is the threshold of Court of Appeal judges? I didn't want you to go into perhaps when hearing a matter of something. I just wanted to know, as statutorily provided, what's the minimum composition of Court of Appeal judges? So the answer here is 12. So what I wanted to test by that is, can you distinguish, between hearing perhaps a matter, composition and hearing a matter, or perhaps knowing that a Court of Appeal will never at any given time have less than 12 judges? The other question that I asked you was about in 5 words or so, I need you to tell me or describe the trial process. So this is how I wanted you to put it, okay? 1, this complaint. 2, this arrest. 3, this charges. 4, this plea. 5, this trial. 6, this judgment. And lastly, there is sentence. So that takes me back to the other question that I asked you to distinguish between a judgment and sentencing. So judgment, this means, the adjudication by the court, that the defendant or accused person is guilty or not guilty. Then you have sentencing now, okay? That sentencing itself is the procedure at which a particular court of law of competent jurisdiction makes an order on the specific penalty to be meted out of the on the accused. Yeah, criminal, because he's been found guilty already. after convicting him, okay? So don't confuse the two. And then the last question that I think I asked you was about the difference between a decree and an order. I wasn't convinced much, but in a sentence, and I asked you specifically to put it in a sentence. So don't be verbose, don't be wordy. Just the way you always have to follow instructions, from the panel. When some tell you to put it briefly in a sentence, just do that because you never know what they're trying to test you. So the difference between a decree and an order in one sentence is a decree is extracted from a judgment, whereas an order is extracted from an interim application. Yeah, so you did well, but I'd implore you to compose yourself. Don't panic, because I think I felt you had sort of rooted yourself out of the equation, and you're trying to find a balance. If it were in a physical, meetup, I'd see that you had panicked, but it's a learning process, and you did well for the start. I think this is the first time you're having this engagement. You did well, and with time, I think you'd be able to master the art and craft of answering oral questions. So yeah, heads up, you did well. So keep on sharpening the iron. Yeah, so that's it. So long.
Thank you so much. Thank you so much. I'm liking today we're doing a lot. Ogola, yes, go on.
Yes, I'm sorry. Thank you for the feedback, and I'll try to improve next time.
Awesome.
You'll do
Awesome.
well. You'll do well.
Thank you.
I'll be honest. When I started this thing, I couldn't answer most of the questions, but by the end of the thing, by the end of my practice and all, I was really, really good at it. Now, Lavin, somebody has asked a question even before I forget. Magiro Halima, she's asked for you to expound on the issue of gifts. Maybe you could do it in 2 minutes, then we move on.
Wow, Probit, you guys, you've I don't know, but I think if we were to do this together with there's something that they also asked us to expound on. I think on section 29 of the LSA and dependence. Yeah, so I'd want perhaps to maybe join the two so that because they are interrelated. So they are independently mutually exclusive of each other, but at the same time they're interdependent in one way or another. So I think if we were to have that intellectual discourse on section 29 of the LSA and section 35 at Waterview, so I think we should marry this gift together with that. What do you people say?
That's fine. Next week, maybe you can have 10 minutes then to open it up for them on that issue. Section 35, section 29, try read the judgment that Ngugi gave, and then maybe in 10 minutes next week, you could do it.
Awesome. I think that's fine.
So, no problem. Now, let's go on to, today we very prepared questions. Let's go to Danson ID. Danson, let's go to Danson, then now we follow the rest. Danson, are you ready?
Yeah, Mr. Solonka, how are you?
Thank you very much.
Allow me to just raise a complaint that people have been lowering other people's hands. I don't know, that's quite conduct unbecoming. Probably let's just allow for those who want to speak to, because I think next time we'll just make everybody as an attendee so that then this doesn't have to happen.
Oh, really sorry about that. You can actually lower someone else's hand.
My goodness, it's happening. So anyway, Mr. Solonka, I'm ready for you.
It's okay. Yeah, sorry. Kindly don't lower anybody else's hand. It's unethical. Okay. You're ready, Danson?
Yeah, thank you. Yes.
Okay. Are you familiar with the Desmond Peters case?
Yeah, many thanks. I think this is a case which has just been asked, and just to a quick recollection is that this is a gentleman who was accused of having snatched a handbag, and one of the issues that came up, I think also the matters of race that were also raised, and indeed it turned out as it had been rightly put that indeed might have been a case of mistaken identity.
Mistaken identity. Now, thank you so much for that. Now, Desmond is your client, and he has approached you saying that appear in court on his behalf, and now he's entered plea. Now, make an oral bail application. Just make a bail application for Desmond Peters, your client, in 2 minutes.
Yeah, thank you very much, Mr. Solonka. Your Honor, Mr. Solonka, allow me to make a bail application for one Desmond Peters, who is my client. And one of the reasons is that Desmond Peters is a man who has never committed any crime for that matter, be it stealing or any other crime before any court of law. And he's been a young man of good behavior. He's actually a man who is respected in the society, having participated even in Christian Union activities within his local church. And he's not a flight risk, and he's willing and able to attend court. So we pray for this honorable court to grant bail under reasonable terms for Mr. Desmond Peters to be able to then be released on bail so that then he can prepare for his defense. I rest my case, Your Honor. Thank you.
Thank you so much. Thank you so much for that. Now, distinguish between, I grant him bail actually. Distinguish between revision and review.
Come again, my apologies.
Oh, no problem. Kindly distinguish between revision and review.
Yes,
Revision
so for many thanks. I think for review, mostly is just to revisit a determination that the court probably has arrived at, the same court, where it on the face of it there was an error in terms of maybe law. So actually the errors on the face of it, and therefore the court can review. But then now when you talk of revision, is where mostly is in sentencing, mostly in criminal cases where then a sentence is reviewed, that word I keep forgetting it, is mostly in sentencing in criminal cases where then a sentence is varied for that matter, either to be changed from let's say a 7-year sentence to maybe just say 2 or 3 years, and the convict is able to be released. Thank you.
Okay, thank you so much for that. Now, let's go to conveyancing. Give me the 3 different ways of, now with the aid of, just give me 3 ways of investigating title, and kindly tell me at what stage each process happens.
Thank you very much, Mr. Solonka. Title is investigated first when you doing an official search, and this official search, you'll do it at the land registry, you'll do it at the register of companies for if the vendor is a company. You'll also do a search maybe even in court for that matter. The second process is mostly where you visit the site itself, and just to establish indeed that this is a property that exists, and what are the dynamics on the ground. And then the third issue could be just then checking, I think I talked about the court, just to establish whether indeed there's the property is in dispute. I think so far those are the areas that you could look at. Thank you.
Now, on to my final question in the field of commercial transactions.
Right.
Let me get the question. What is a derivative action?
A derivative action or claim for that matter, I think it falls under the exception in the Force v. Habertol a case where a shareholder could bring a claim on behalf of the company, because ideally companies are known to be entities separate from the shareholders, being able to sue and be sued, and of course having that issue of perpetuity and common seal. But then now here, a shareholder is allowed to bring in a derivative action because of a number of reasons. And I think maybe the scope of this question might not have focused on that, but I believe indeed those are the exceptions that I highlighted in the case of Force v. Haboto. Thank you.
Thank you so much for that. I will give my colleague Lavins to give his questions, then we'll revert to the comments.
Thank you very much.
Thank you. Thank you, colleague counsel. Mr. Danson, how have you been today?
I've been great. Thank you very much, Mr. Patrick.
Awesome. Are you happy to be here?
Absolutely.
Great. So I'll go straight to the point. Could you kindly name the types of pleas?
Please,
and
I
what
think
they start for?
yeah. Yeah, thank you very much. I think this is also a question that came up last time. We had agreed that indeed the pleas could be a plea of guilty, plea of not guilty. And the procedure for plea taking, as I had mentioned to it, was also in the case of Adan v. R. In the Court of Appeal, which gave a procedure on how that has to be undertaken. And of course, the third one is Ultra 4 Convict and Ultra 4 Acquit. So those are the three.
Awesome. So assume I'm the DCJ, okay? I'm the Deputy Chief Justice, okay? Are we together
Right.
up to that point?
Yes.
Great. So I have committed an offense, a criminal offense.
Yes.
And I've been charged and I've been taken to a magistrate court, okay?
Yes.
And so during plea taking, are we together
Yes.
up to that point?
Right.
Awesome. So during plea taking, I refuse to take the plea.
Right.
So what happens when one refuses to take a plea? So a person like me, I'm the DCJ. Of course, I hold a public office. So I have refused to take that plea. So what happens? How do you think the prosecution? Now you are the prosecution. You are Haji, okay? So how would you proceed from there? Yes, you've charged me, but I have refused to take my plea. How do you proceed from there?
Thank you very much, Mr. Patrick. And indeed, though facts seem to be a bit, I would say, theoretical, but indeed this is something that has happened. When an accused person refuses to take a plea, and I think this is one of the cases that, remember Article 49 of the Constitution, a person is at liberty to maintain silence throughout the entire process of prosecution, and therefore no law compels the person to speak. And in that case, at the first instance, of course, the court has two options. One is to establish whether this person is of right mind or whether he has some mental issues. And this being a DCJ, the assumption is that indeed this is a person of sound mind, and therefore the court is meant to enter a plea of not guilty for that matter. Because this was held actually in one of the High Court cases. So therefore, the prosecution then will move to ask the court to enter a plea of not guilty, and then proceed to now issue, or rather give an opening statement to now charge the person, to prosecute now the case. Thank you.
Thank you. And my third last actually. Right. So yes. I have proceeded as a DCJ, okay, after refusal to take my plea. So yes. I have said, okay, I will instruct my lawyers to file a petition in the Constitutional Court. Yes. So my question is, remember you are charged in a magistrate court, okay? I hope you are following keenly.
Right.
Awesome. So I have proceeded to instruct my lawyers, okay, to file a petition in the Constitutional Court. So what power does the magistrate court have? The magistrate court where I was charged in. So what power does that court have?
Thank you very much. And I think the magistrate indeed has that jurisdiction to continue with the criminal case. But however, the High Court will then give directions. Remember, Article 165 gives the High Court authority to supervise all these subordinate courts. So unless up until an order comes out from the High Court in a constitutional petition, maybe in the form of an interim injunction, suspending or rather halting the proceedings at the magistrate court, then, and that order has to be served on the magistrate personally. Unless the magistrate has seen that order in person, and then the proceedings will have to go on, and therefore the authority of that court will not be interfered up until an order comes out. I hope I've answered, not unless I missed the question. Thank you.
Okay, my second last question. What
Right.
is the jurisdiction of the Supreme Court in criminal matters?
Thank you very much. The jurisdiction of the Supreme Court under Article 163 is on criminal matters is mostly through an appeal from the Court of Appeal, and this appeal should be a matter that raises an issue of public interest, like now what we saw in the Francis Murwatetu case, and no other forum, in my view, can arise unless, let's say, under Article 144, where the CJ then is required to support the panel for assessment of, let's say, a president who has insanity or those kind of things. But other than that, in fact, on election petitions where presidential elections arise matters to do with electoral offenses in a presidential election, then the same has to be remitted back to the trial court for purposes of prosecution. Thank you.
My last question. You are the
yes.
Solonka, my learned senior Solonka is the deputy president of this country, okay?
Right.
And you have sort of made threats to Solonka and the holder of the office, okay?
Yes.
Are we together?
I have made threats to the deputy president.
Yes, you have made threats to the deputy president.
Right.
You have been charged with the crime of treason, okay?
Yes.
So my question is,
yes,
are these threats on the deputy president's life amount to treason? And why?
Thank you very much. And just maybe, Patrick, if you allow me to just also answer the immediate previous question, also the issues of contempt of court. I think this was also held in the Malcolm Bell and Daniel Moy case, where the Supreme Court said that indeed it has jurisdiction any court has jurisdiction to prosecute, institute criminal proceedings in the matters of contempt of court. So back to the issue of treason, I think this one is in section 40 of the penal code, and the offense of treason really is against the threat to the life of the president. The president, or where you are assuming or you intend to, it's quite archaic and colonial where you say then you want to overthrow the government. But now threats against the deputy president, I mean, who is he? Really, the law, we can threaten as much as we can. Nothing will happen in as far as charges of treason are concerned. Thank you.
Awesome. Solonka, that's all.
Thank you, man. You did very well. You did very well. Seriously impressed. You did very well. Now, my comments are, on the first issue of revision and review. So you got it rightly. So maybe compare up below with it. So for review, it's under Order 45 of the Civil Procedure Rules, read together with Section 80 of the Civil Procedure Act. So for review, it's where there is new fact or new evidence that have arisen and they were not readily available or present during trial. So you can approach the same court that had the matter to do what? To review the case afresh, to hear the case afresh and then review it. You got that one right. Revision, you also got it rightly. It's under the criminal jurisdiction. Now for revision, the court that has the jurisdiction is the High Court. So the High Court has the jurisdiction to do revision, and it calls on the records and it checks on three main things.
Right.
Now the three main things it checks is on the propriety of a sentence, the legality, and the correctness of a sentence. Those are the three main things that the court limits itself to when it comes to revision: propriety, legality, and the correctness of a sentence. The section is section 162 of the civil procedure, or not the criminal procedure code. You've got it correctly. You got it correctly. Now, the other one is investigation of title. Now, maybe to clarify on that, when you ask that question, now it depends on the lecturer, which Mr. Ayera, okay, generally, revision, not revision, I mean, investigation of title happens in three main ways.
Right.
You do a search, you can either do a search. Now, under searches, there are different types of searches, but the three main ways are: one, search; two, pre-contract inquiries. Now, pre-contract inquiries is what you mentioned, going to visit the property physically and trying to look at, the location of the land, the neighborhood, what's the condition of the land. That's now pre-contract inquiries.
Right.
Then the last one is through requisitions. Now, for requisitions, these are basically questions relating to title. Yeah, and it happens after executing the sale agreement. You can go read condition 6. Law society conditions of sale 6.5. Condition 6.5. I'll just check right now and then confirm before Lavins finishes. Condition 6.5. Condition 6.5 of the LSK conditions of sale. So there are three main ways. Searches, you got that one correctly. Searches. So even if you mention all those types of searches, search at the lands registry, the official search, a company's registry, the postal search, historical search, and so forth, they are all under searches. The second one is pre-contract inquiries. How do you do pre-contract inquiries? Visit the area, see the land, check the neighborhood policies, and so forth. And the last one now is requisitions. Requisitions is also a question, is also a method of investigating title to land. You got that one correct. Now, on the last issue of derivative action, you got it perfectly. You got it well. Now, just to clarify to the rest, when you talk about derivative action in the aspect of what commercial law, it's a mechanism which allows shareholders to litigate on behalf of the company. So you're bringing this suit on behalf of company. You're not bringing the suit on your behalf. You're bringing the suit on behalf of the corporation. Yeah. Now, the action is usually designed as a tool of accountability to ensure redress is obtained against all wrongdoers in the form of, maybe there is a majority shareholder or a director, or engaging in some activities that are not in the best interest of the company. So you take the suit and bring it on behalf of the company. That is derivative action. And they usually like to ask this question and try to contradistinguish it with unfair prejudice petitions, which is a totally different thing. Now, let's say the company does something against your interests, you bring an unfair prejudice petition, section 700 and something of the Companies Act. I'll confirm it and send it there. Other than that, you did very well. I'd give you 19 out of 20 or 18. You did performed extremely. Thank you for that.
Great. Thank you so much.
Awesome. Danson, first of all, I'd say I'm impressed. It's I think had it not been for time, I'd have wanted you to, to keep defending your answer, because I was surprised that you're vast. When you told me like it wasn't really a hypothetical question and it's a real life question. Yes, it is. And you think, like for a panel, I'd have given you extra marks. So you are, like this is an existing case. But for the purposes of, perhaps discussing, the aspect of sub judice, trying to discuss an ongoing matter and everything. So I'm trying to fix in a hypothetical situation so that you get the gist. I'm impressed that you actually knew that was an existing case. Yeah, so for the rest of you guys, it's a real life case. Yeah, that's it. So I think that's what extra miles of reading does to the mind. It makes you retain information because you never know when you'd use this. So going straight to now my feedback, I'd start with the last question as climb up the ladder. So the threats, did your threats on the deputy president life amount to treason? You're right. And thank you for even quoting the section 40 of the Penal Code. So you see, guided by section 40 of the Penal Code, the actus reus element of treason as an offense, the said treasonous act must be directed at the president. So the deputy president is not a president, and therefore this provision shall not actually apply to him. So you did that. I mean, you stated that categorically, defended, had something to back it up. I was impressed. The other thing is the jurisdiction of the Supreme Court in criminal matters. Thank you for quoting Article 163 of the Constitution. So the Supreme Court, has appellate jurisdiction from the Court of Appeal on criminal matters on purely points of law of significant public interest. And you answered that, very well. And the only last thing I actually wanted you to mention, it's on a point of law and not facts. So the moment you insert that, like it's on a point of law, the examiner already knows that you know what you're talking about. You can't argue facts before Supreme Court. Never. So it's on a point of law. Thank you. The other question I asked you was about, the case scenario now on the DCJ. So you see, you slightly got it, but the answer to this, what happens when a DCJ or a person like me or anyone refuses to take plea? What does it amount to? So there's something called deferment of plea, okay? So deferment of plea under the law, allows for the taking of plea at a later date, pending the directions and or hearing and determination of a substantive issue affecting the charge, of the accused by a higher court. Okay, so the higher court in this case is the High Court now. So now this brings me back to the second question. I have filed a petition in the Constitutional Court, like I have instructed my lawyers to do that. So what power does the magistrate court where I was charged at have? What power does this magistrate court have? So the answer to this is they do not have any power, as a matter that is being dealt with by a higher court cannot be simultaneously dealt with by a lower court. Article 165 of the Constitution of Kenya 2010 provides for the jurisdiction of the High Court. So the High Court has what we call a supervisory jurisdiction over subordinate courts. So this is why, they will always, once they've taken up a matter, the subordinate court may never, get hold of it, okay? So they don't have any power as that matter, over that matter, because it is being dealt with by a superior court, and it cannot be simultaneously dealt with by the same magistrate court. My last question was on the types of pleas. There are actually 5. No, there are 6, and you mentioned 3. I think you've only No, I mean it is taught in criminal litigation. There are 6. So the first one is the plea of not guilty. The second one is the plea of guilty. Okay. Third one is the plea of ultra fois acquit. So in the plea of ultra fois acquit, this is where the accused is charged and acquitted of the similar charges under the same facts. And then the next type of plea is the plea of ultra fois convict. So in a plea of ultra fois convict, this is where the accused person is charged and convicted of similar charges, again, under similar facts. And then the other plea, which in civil litigation, you'd call it res judicata. So in criminal litigation, because a panel they could ask you what's the difference between this type of plea and res judicata in civil, okay? So the next plea is called double jeopardy. So this is where the accused was already charged on the charged of the same crime under the same facts. And then the last type of plea, which is normally put under what we call pardon. Okay, so here it means the accused says, okay, I'm in court, yes, but I was previously pardoned over the same particular crime. Okay, yeah. So the other type of plea that is not really a plea is immunity. Okay, yeah. So those are the answers I needed, and you did very well. And yeah, I'd give you 18. Yeah, I will. Thank you. You've made my work easier. I was happy listening to you, and it's a thumbs up. So keep on keeping on. I think in 5 years' time, you'd be somewhere far. I don't know where, but I think your stars are aligned, and there's a particular trajectory that you're following, which will be quite, magnificent to the rest of the, perhaps the Kenyan populace. But thank you. You did well,
Amen.
and looking forward to
Amen.
more engagements. Yeah, so that's it. I'm proud of you, and keep on oiling the wheel. Yeah, so Solonka,
Amen.
back to you.
Thank you so much.
Awesome.
Karibu sana. Yeah, so maybe somebody else asked a question in the group. So yeah, I was saying distinguish between derivative action and unfair prejudice petitions. The statutory provisions for both of them are for derivative action is section 238 of the Companies Act, and for unfair prejudice petition, it's section 780 of the Companies Act. So the main difference between the two is for derivative action, you're bringing it on behalf of the company. Now for section 780 unfair prejudice petition, you're bringing it on your own behalf. If you read the sections, you can see that. You can have a look at that. Now, thank you for that. Thank you for that, Danson. You've done extremely well. Thank you for that. Now,
thank you so much.
Mushiri Marion. Now I see Alex has joined. Alex, are you in? Alex Mwendia.
I'm in.
Okay, you're in. Okay. Mushiri, are you in?
Yes, I am.
Okay, thank you. So Alex, since Alex has joined, Alex will take the first batch. Then Lavins and I will contribute. We will contribute to it also. Lavins can go after Alex. Alex begin.
Hello, can you hear me, Moshiri?
Yes, I can.
Okay. Let me ask you just a few questions, and then we can discuss later and see how you perform. I hope you have been listening to how my colleagues have been asking questions and the feedback they've been giving, and I hope that you have taken some points from them which you can use in answering these questions. So the first question is a succession question, which is can a non-Muslim child or wife inherit from the estate of a deceased Muslim's property in Kenya? Can I repeat? Can a non-Muslim child or wife inherit from the estate of a deceased Muslim in Kenya?
Well, no, I do not think that they can inherit in Kenya because the Law of Succession Act provides that Muslims are not governed by the Law of Succession Act. So I do not think that their inheritance will be governed by the Law of Succession Act.
Okay, don't you think that is discriminatory when you look at it as compared to Article 27 of the Constitution?
Yes, I think it's discriminatory and it's unfortunate. But in my opinion, even if they will inherit, they will inherit in accordance to Muslim law. Only now the procedures that will be followed would be in accordance to the Law of Succession Act, or they will just not be. They are not supposed to be
they are not supposed to be in contravention with morality and repugnant to justice.
Okay. Thank you for your response. The second question I would ask you is, what is the difference? This is a commercial transactions question or a commercial law question. What is the difference between a company limited by guarantee and a company limited by shares?
Okay. A company limited by guarantee, I believe, is provided for under Section 3 of the Companies Act. A company limited by guarantee is where members of the company, or rather shareholders of the company, take up, or rather say that they're going to pay a certain amount of money in the event that the company is being dissolved. But a company limited by shares is where shareholders of the company, their liability is limited to the extent of their unpaid shares.
Okay, thank you. Third question is, just state the 3 ways of investigating title to land. I know this question had been asked before, but I want you to answer it again. The 3 ways of investigating title to land.
Oh yeah, it's actually been asked before you joined. The 3 ways of carrying out investigating title to land will be: number 1, carrying out searches in various registries, for instance, the land registry, the probate registry, the company's registry. The second one would be requisitions, where you ask questions in regards to the title. Say, for instance, you're asking whether you're asking the vendor whether their land is charged. So you're just ideally asking questions to know whether you'll get good title for your land. And the other one is pre-contract inquiries, where you visit the actual site. You could get, say, for instance, surveyors, valuers, to ensure that the land that you're buying will give your clients good title.
Mm-hmm. The fourth question, can you say 2 movable properties which the MPSR Act does not apply to?
Sorry, you come again, please.
Sorry, 2 movable properties. 2 movable property. You know the movable property security Act applies to movable property when you're securing when you're using such movable property to secure yourself.
Yes.
So can you say only 2 movable properties which the MPSR Act does not apply to?
The first movable property that the MPSR does not apply to would be, is it shares, not shares, certain companies that are governed by the Depositories Act. Those ones are not guided by the MPSR. The other movable property that's not governed by the MPSR would be, honestly, do not have it on the top of my head right now. I think I'll just go research on it.
Okay, thank you for the attempt. Lastly, what was the principle in the famous case of Donoghue versus Stevenson, 1932?
Yes, the Donoghue versus Stevenson is a locus in the law of negligence. It provided for the good neighbor principle, and it establishes certain criteria that ought to be followed before we can establish that there has been negligence. It starts by saying that a neighbor is a person who has proximity to you and to whom you owe a duty to, so that if you do not perform that duty, they will stand to suffer damage. So in essence, it establishes the neighbor principle.
Okay, thank you. I think that's the end of my questions. Maybe I don't know if I give my response before Lavin asks the questions, or I can just or Lavin should first ask questions.
I think we can ask to be more practical. So Lavin will ask, then you both can give your question.
Okay.
Lavin, see you in.
Oh, sorry. Thank you. Yeah, so To whom am I asking the question? Mushiri?
Yes, Mushiri.
Oh, awesome. So, Mushiri, how are you?
Fine, thank you. How are you?
I'm well, thank you. So I have 3 questions. So my first question, a demand letter is not advisable in 2 instances. So which instances are these? That you're not advisable to write a demand letter when 2 circumstances arise because of the impending consequences or because of the urgency of the matter. I think I've even given you a clue. So which 2 instances are these?
Yeah. Ordinarily, you're supposed to send a demand letter before you can institute any suit in civil matters. But there are instances that you're exempted from sending a demand letter. It's in instances where you're seeking Mareva injunction and an Anton-Pila injunction. In a Mareva injunction, it's because, say for instance, the person you have a suit against would remove the subject matter from the jurisdiction of the court. So sending a demand letter would prejudice you because they would have probably already moved it from the jurisdiction of the court. And in Anton-Pila injunction is where also in the same breath, where for instance you want to entry to a particular premise to get documents that will be very critical in your case. So sending a demand letter would also prejudice your case.
Right. My second question, which is the only court that is established or is a creation of the statute?
Sorry?
You heard me?
Sorry, what?
Did you hear me?
Yeah, you asked which is the only court that is a creation of the statute.
Yes.
Well, I think the way I understand the question, I think all the courts are a creation of the Constitution because they're provided for in the Constitution. Also, they are enabled by various statutes. Say, for instance, the ELT court is enabled by the in the ELT Act, but I think the only court that is a creation of statute would be, in my opinion, the small claims court, because it's not anywhere in the Constitution.
Okay, thank you. My last question, do you follow cases in a public domain?
Yeah, I do. I try.
So could you kindly give me 3 bad facts for the prosecution in Obado's case?
Yeah. In that case, 3 bad facts for the prosecution in Obado's case. Number 1 would be Sharon. The first bad fact for the prosecution would be there was no DNA for Obado that was found on Sharon's body or on her undergarment. The second bad fact for the prosecution in that case would be that there was no direct link. There was no direct link to the main suspect of the crime with the murder of Sharon. And the third bad fact for the prosecution, in my opinion, would be that honestly, I have never thought about bad facts like that. I would have to go reread the case and figure it out.
Awesome. That's all for today. Thank you.
Thanks. Now Alex can give his feedback and then Levins.
So I think Moshiri did very well. In my opinion, I think she, as I like to say, she knows her stuff. So just to give a feedback as to with regard to the questions that I asked, the first question was can a non-Muslim child or wife inherit from the estate of a deceased Muslim? And she was right. She was very right. The answer is no. To understand the background of that position, I think it's important for people to look at the case of re-estate of CCBH 2017. In re-estate of CCBH, it was those were the facts. Whether people and non-Muslims can inherit from the estate of a deceased Muslim, and the court said no, they cannot inherit because Article 27 is not one of the non-derogable rights. The right to non-discrimination can be limited under Article 24, and of course, the Law of Succession Act limits its applicability to people who are not Muslims. So you can look at that case. The second question was the difference between a company limited by guarantee and a company limited by shares. She was also right. A company limited by guarantee is a company in which the members. But she missed the section. The sections are section. Look at section 5, 6, and 7 of the Companies Act 2015. Section 5, 6, section 5, if I remember well, talks about types of limitation of companies. That a company can be limited by shares or limited by guarantee. And then I think section 6 talks about companies which are limited by shares, I think. And then section 7 talks about companies which are limited by guarantee. Basically, a company which is limited by guarantee is a company is where the members of such a company pledge or say in the memorandum of association that they will contribute a specific or a certain amount of money when the company goes into liquidation or when the company is liquidated. So if we have formed a company, me and Molshir, and then we say after we liquidate this company 10 years from today, I will contribute 100,000 and she contribute 100,000. That's a company limited by guarantee. There's a specific money which I've already pledged to contribute. But then a company limited by shares is a company. It's a company which the liability of the members is limited to the amount of money that they have not paid for the shares which they have subscribed to. So if I have a company and I've subscribed to 100,000 shares of 10 shillings each, it means that I should have paid to the company 1 million shillings. If I took the shares of the company, that is 100,000 shares, and I only paid 5 shillings each, it means I've paid 500,000 instead of the 1 million which I'm supposed to pay. So if the company goes into liquidation, my contribution to this company will be limited to the amount of money that I have not paid on the shares which I subscribed, which will be 500,000 shillings. I hope that is clear. I think she got that right. The other question I asked was, what are the 3 ways of investigating title to land? I think she missed this question. There are 3, in my opinion, there are 3 ways of investigating title to land. The first one is what is called an official search. An official search is the most appropriate or the most recommended way of investigating title to land, in the sense that you make an application to the registrar, to the land registrar. That is, if you're in Nairobi, you make an application to the land registrar in Nairobi. If you are in Kajiado, you make an application to the land registrar in Kajiado, and of course, they will conduct the search for you. The importance of this search is that, and why it's the most important search, is that it enjoys the government indemnifies this search, because the people conduct this search are government officials. So if you are misrepresented, in case they tell you, this title is good, and then you go and find out that it was a fraudulent title, Section 81 of the Land Registration Act entitles you to claim compensation from the government. So there's the official search, which is the main search, which is the most important search, which is a search which you must do. Then there's another search which is called the personal search. A personal search is done by the advocate. You go to the land registry, you request the land registrar to be allowed to access the documents, and then you can look at how the transactions happened over time. And then the last search, I think we used to call it the historical search, which is a search involving looking at the correspondence between different departments in the land registry. This search is also important because you can trace back the title of the land from the time which the land was allocated to the current day. You can be able to see how the different departments within the land registry or the Ministry of Lands were corresponding with regard to a particular piece of land. So those are the three ways of investigating title to land: historical search, personal search, and official search. An official search for purposes of conveyance is provided for under the Land Registration General Regulations 2017. When you look at Form 84, Form 84 is which I think it provides for how an application for an official search looks like. Just look at those regulations. You should go through them. And then Form 85 is a certificate of official search. Once the department has conducted the search, you'll be given a certificate in Form 85 of the Land Registration General Regulations. I like to call it the legal notice number 278, just to avoid the long name. The other question I asked was the principle.
Alex, you're muted.
Yeah, Alex, you're muted. But maybe on that aspect, on the investigation of title, Alex.
Yes, can you hear me now?
Yeah, I can hear you. On the investigation of title, on what Mushiri just said, you have given 3 types, but you've only based it on searches alone. You've only expounded on searches. What about the others? Pre-contract inquiries, requisitions?
Exactly. Yeah, those are the other methods. There's a contract inquiry. Yeah, those are the
and searches. So whenever you're given a question on investigating title, you expound it the way Alex has expounded it on searches. Search, there's official search, there's historical search. And then now after you've done expounding on that, because all those are searches, you move on to the next step, which are pre-contract inquiries. Now, what does pre-contract inquiries entail? Information you get from a search, you cannot get the full information from doing an official search. You need to elicit other information. For instance, the neighborhood policies, development prospects, issues to do with the physical condition of the land, the neighbors, people in occupation and their status, and so forth. That is now pre-contract inquiries. You check the conditions and so forth. And then now the last one is requisitions. Under LSK conditions of sale, condition 6.2, you can check LSK condition 6.2 on the issues of objections or queries that are raised after deducing the title documents. Yeah. So those are the 3 main ways, which is the search, the pre-contract inquiries, and the requisition. Now you expound it further. Now, for instance, on searches, you bring historical searches, official searches, all those others. I think she answered that one on that particular aspect very well on that. Just now.
Oh, okay. I think I missed I think I'm forgetting these things. Yes, but you are right.
It's okay. Yeah.
Okay, so I think did I talk about the before I got muted? The principle in Tony versus Stevenson. I think she got it right. The neighbor principle, Lord Atkin in that case, where he said that you have a duty of care for your neighbors. And then my last question was 2 movable properties which the MPSR does not apply to. So these are found in, I think it was Section 4 of the MPSR Act. Section 4 of the MPSR Act says that it does not apply to, I think she got the part of the shares. You see, when you have shares deposited in it's called the Central Depository System, CDS account. For example, if CDS account applies to listed companies which are in the NSC, Safaricom, Kengen, KCB, Cooperative Bank, those companies. If you have shares list of a listed company, they usually you don't have a share certificate. The shares are deposited in something which is called a Central Depository System, CDS account. Such shares they are movable property, yes, but they cannot be held as they cannot be used as security pursuant to the MPSR Act. Then I'll give you two simple ones, two more simple things you can remember. Ships. You know, the Act says that provision says the Act does not apply to ships under I think it is the Merchant Shipping Act. Very simple. The third one would be aeroplanes. The aeroplanes and I think the KCAA Act, kitu kama hiyo. So just look at that section. And by the way, you guys should read the MPSR Act. Just make sure you read from section 3, the objectives of the Act, to section 15, and then you read section 17 to 30, and then you read section 67 to section 70, because you will not miss a question in the by exam, because that's a new area. It was not there before. They introduced it 2 years ago into the syllabus, so they must. It's a new area, so they must. Even in our sitting, it was there. So just notice and just go through those provisions, because if you get a question from MPSR Act, those are 10 free marks. Because it's very short and they cannot twist a question. It will just be very open for you. So thank you. I think Mosheri Marion did extremely well. Thanks.
Awesome. So
Sorry for interruption. Sorry for interrupting, Alex. Kindly come up again on the specific sections of the MPSR Act.
Okay, thanks. Look at section 3 to section 15. But sana section 3 to section 10. Section 3 to section 10, look at section 14 and 15, and then look at section 17, which talks about the registry and its creation, to section 32, 33. Section 32 and 33 talks about the period. They should not be more than 10 years. They can be extended for another period, I don't know, of 10 years. And then look at section 66, 67, 68. Those sections talk about the remedies. They are the same as section 90 of the Land Act. Which remedies does a credit have under the MPSR Act? They can sell that property, they can take possession of the property, those things. A question will be brought around those sections. It's very easy. If you just look at those sections and understand them, it will be. I hope you have got the section 3 to section 10, section 15, section 17 to 33, and then section 66, 67, 68.
Well noted. Thank you.
Welcome.
Solonka, thank you. Thank you, Alex. And welcome aboard. So my feedback on the questions I asked. I'd begin with the Obado's case. Yeah, you see, when you ask such questions, the panel want to test, do you follow, public interest cases? There is Obado's case. There is there's this one that is being handled right now. Oh, there's the Willie Kimani's case, by Justice Lesate. There are quite a number. Yes. You see, I mean, any public interest cases, do you follow them? So for me, the 3 bad facts for the prosecution, because Mr. Maniki is always, like when you're answering such a question in an exam, best believe Mr. Mwaniki's voice will always ring at the back of your mind because of trial. You've handled Desmond Peters, you have handled Faith Mweni and Eric Mwoki. You know the bad facts, the good facts. Because the rule of the thumb is the bad facts for the prosecution are the good facts for the defense and vice versa, okay? So the 3 bad facts that I wanted for this particular case, Obado's case, which I think the hearing was the cross exam of the witnesses. I think the trial was postponed to October next month or late this month. I'm not sure, but the last time it was cross examination by Professor PTO Ojienda, that is. Yeah, he's called PTO. Yeah, so I mean, that was where I last left it. So the 3 bad facts for the prosecution: 1, Obado was not present at the crime scene. Okay, that's 1. 2, Obado was present at another place at the time this particular crime was being committed. And then 3, Sharon was carrying, Obado's child. Hence, he would sort of lack motive to kill that particular child. So I think there are a number of facts in this case. It's still an ongoing case. That's why I don't want to discuss it that further. But I just wanted to get the gist. Okay, like get hold of these facts. The cases that are that have taken the country by just get to understand them. So the other question that I asked you was about what's it? Could you wait? Yeah. The court that is established, that is a creation of the statute. Yes, you got that right. And I love the way you're trying to break down everything. The Constitution doesn't expressly provide for the Small Claims Court. You see, the Small Claims Court Act itself creates that particular court, the Small Claims Court. And it sort of, gives it the power to handle the cases within a limited specified period of time, I think 60 days. And also the judicial officers are referred to as adjudicators. Like, it's a court that has its own rules. It is not being governed by the rules of evidence or the rules of the civil procedure. It has its own rules that govern, its operations. So yeah, that's the only court that is a creation of the statute, okay? And by a creation of the statute, I mean that a statute that expressly creates this particular court. Of course, each and every court, you have the Supreme Court, there's the Supreme Court Act and its underlying regulations. But no, the Constitution itself establishes the Supreme Court under Article 163. So does the Court of Appeal, 164. You see? So that's exactly what I wanted to tell us. And thank you. You did that. You did answer well. What is the last question? There are 3. Oh yeah, the 2 instances where a demand letter is not advisable. That one you did well. So whatever you want to make an application for a Mareva injunction and antopela. So such order and getting hold of a specific property, you are not advisable to write a demand letter to that to the adverse party, okay? Because by the time maybe that you write this particular letter, the property would have been taken somewhere, or perhaps the documents or anything of the material that you need would have been confiscated, okay? So those are the 2 instances where you're not advisable to write a demand letter, and you did perfectly well. So Mushiri, yeah, you'll do great. I have a feeling you'll emerge victorious, in orals, and I love your composure, your comportment, your mien, and basically your confidence. Yeah, so they all, work well with you. So yeah, keep on reading widely, especially on the current affairs issues. Maybe that's the only part that may derail your progress, but there's still time. You still have time. So start as early as tonight. Keep yourself acquainted with all these public interest affairs. And before I rest my case to Solonka, the case that Alex mentioned in the matter of CCBH on the inheritance by non-Muslims, okay? Could you kindly sort of compare and contrast with the case of Chelanga versus Juma, okay? Because the case, the re-estate of CCBH sort of mentions Chelanga versus Juma. So try and read both cases to be able to, understand more, for the right of inheritance when it comes to a non-Muslim who was married by a Muslim, okay? So where does the Sharia law fall? I mean, is there any conflict between that and I think Article 24 or something? Yeah, so that's it. Ladies and gentlemen, back to you. Shalom.
Thank you very much, Lavins. Mushiri, you did extremely well. Extremely well. Extremely well is actually an understatement. So you've done extremely well. So who else do we have here? Who else wants to volunteer? There are written names. Some guys who had asked questions initially. Who's volunteering? So that I take them through. Maybe just a commercial break for how many minutes? And maybe let me just commercial break for 2 minutes and give you maybe some slight history of maybe I can give you some history about me. Then I will go on 4 minutes. So this is like if you're shy or anything, maybe to try and boost your confidence and all. So for me, I never used to speak at all in class. I will never speak in class. Okay, not in KSL when I was in campus undergraduate. I never used to contribute in class. I was very shy. All I was scared of asking questions, thinking, what will other people think? All. But then the thing is, I tried to, as much as possible, get out of my comfort zone and to, because I knew in the legal profession, one way or another, unless you want to just practice corporate, and even if you're practicing corporate law, you'll have to go and meet CEOs. You'll have to attend conferences where you'll have to speak audibly because you're a lawyer. People expect you to speak audibly. So I slowly tried and boost my confidence. So, during campus, first year, I remember the first times during matriculation and orientation, I met Lavins. We met Lavins from the first day, actually. And he was always confident. He would speak, raise points in class, raise questions, contribute and all. So I would sit with Lavins, another friend of mine known as Morara. There was Morara. I don't know if you guys know him. Morara Kebasu Morara. So I'll sit, and these guys will actually help me get out of my comfort zone, and they will actually encourage me and be there. So I would really panic before asking a question, but eventually it took some time. It took some, maybe during campus. I started being confident when I was in that year. You can see that year, for the year. And now up to now, all my fright issues and just thinking how people will react to what I say, it totally went. And I can comfortably tell you that I am not a genius. I am seriously not a genius. I don't have anything special with me. Lavins, I don't know if he's a genius, but we went through the ATP program and we managed. You guys will also go through the ATP program, you will manage. Thousands and thousands of people have gone through the ATP program and they managed and will still managed. So for me personally, I can tell you that I got out of this school. I don't know if you guys know Kabarak High School. I was in Kabarak High School for the first 2 years, Form 1 and Form 2. But then I never used to perform very well in that school. I never used to get good grades. I would perform poorly. I used to be in this cocoon or where I wasn't just bothered with anything at all. And that thing led to, that comfort led to one thing or the other. And I was removed from that school and I was taken to another school in Kajiado County known as Mashuru. I don't know if you guys know that school also. But the school in Mashuru, when I went into that school, it was actually in the newspapers, bottom 10, among the bottom 10 schools in the country. So it was among the bottom 10 schools in the country. So check the irony in that. I was from the best school. At that year, I think Kabarak was number 1 in KCSE, the time when they used to announce. Then to announce the results and post the best schools. Then I went and transferred to a school which was the bottom 10, actually in the newspaper. And you see the funny thing is the principal went and put it in the notice board. So that even, when you guys are coming to school, maybe for sports from the sub-county and everything, they just see and you could just imagine that kind of context. It's a remote district school in the country, deep within Kajiado. When I was going to the dormitory, I was chased by hyenas one way or another, something of the sort. but that didn't really define who I will be in the future or what I'd come to do, because Kinala Vince and Alex can attest, I've had serious progress. It just begins from the mindset. It begins with believing in yourself. If you pray, so it goes further to pray. It goes further. You go further to, pray if you want to pray. Begins with the mind, and all will be well. I went through campus. I was among the best students at campus. Okay, I didn't get a first class. I don't know what happened, but I really wanted, but I didn't get it. But I was among the top students in class. I was a pace setter. I went to Kenya School of Law. I got 19 in my orals. We progressed. Did the bar exams. I got what? I got good grades because I had over the 9 units. I had 4 80s. 4 units above 80, my highest being 88. I had 170, and then my least grade was 62. And I can comfortably say I'm not a genius. Like, I don't know if any of you have studied in a school where it has been listed as the bottom 10 in the country. So don't ever feel inadequate. Don't ever feel like you don't know. I've been there. Trust me, it's just the perception in the mind. Start believing in yourself. Raise your hand up in class, get the question wrong. People will laugh, but for how long will they laugh? Guys laughed at me when I was in cover up. How many can laugh right now? So just believe in yourself and do it. Just do it, and you'll manage. And that's why I say I'm not a genius, because I've studied in both extremes. The bottom was at the top at one point in life. So that was just something to motivate you. So I can see Muturi has his hand up. So we can go on. Muturi, can we go on with you? I was actually going to list you because you asked us. We go on, huh?
Yes, Mr. Ronka.
Okay, so I'll take you through with, I'll ask you a few questions, then maybe Alex and Lavins, whoever is prepared, will do so. So for me, the first question, distinguish between or list 2 powers of a director and 3 duties of a director. And while at it, distinguish between the powers and duties of a director.
Thank you for that question. I'll say a director is an agent. I'll start by defining a director is an agent of a company. And one of the duty is to manage the company affairs and to ensure that everything goes as per the objective of that company. And also the directors, they call for meetings, and that is if there is need for any special meeting, and also to send notices for such meetings that may arise. And they also, what was the next question? The duties and
like you distinguish between duties and directors, and you could if you can you list 2 duties of a director and 2 powers of a director. Distinguish between duties and powers, list 2 in each.
Okay, thank you. What I have just stated are the powers of the director or directors of a company. That is they have that power to manage the company, and also to ensure that everything with regards to the operation of that company goes as per the requirement and as per the stipulation of the articles of such a company. And the same case applies to the duties. I feel like they are more related and connected. And so for that, I will rest my case there.
Okay, thank you. Thank you for that. Now, what is the difference between an ordinary resolution and a special resolution?
Thank you, Mr. Soronka, for that question. For an ordinary resolution, it is made, although we are not yet there, but I believe we did this in our undergraduate. But for an ordinary resolution can be made during the annual general meetings of a company, whereas for a special resolution is made in special circumstances, where, for example, there is need to remove a director. It will be done through a special resolution, or there is an urgent matter that calls for a special meeting. Then in such what will arise out of such a meeting will be a special resolution. Thank you.
Okay, thank you. What is the cab rank rule?
All right, thank you for that question. The cab rank rule is where the directors, they have or they can institute a suit on behalf of a company. Therefore, it means they will sue on their names, but on behalf of the company, and they'll be acting as agents. So yes, that's my understanding.
Okay, thank you. Now, what do you need to prove in court for you to be granted an injunction?
Thank you very much for that. Injunction are provided for under Order 40 of the Civil Procedure Rules 2010, and there is a Rocas Classica case when it comes to injunction. That is, am I forgetting the case? But generally, you have to.
Giela versus Cashman Brown. Yeah.
Thank you. Giela versus Cashman Brown. But you have to prove, number one, that you have a prima facie case that has high probability of success, and then you have to show that you will suffer irreparable damages that cannot be compensated an award for damages. Then you will have proof that the balance of probability is on the point. Thank you.
Oh, thank you for that. Thank you for that. Now, my last question will be, there are male and female judges in the High Court, yes? How will you refer to them? How will you call them?
Sure. Thank you for that question. For the male judge, I'll refer to him as my rod. And then for the lady, I'll refer to my lady.
Thank you for that. Thank you for that. So for me, I'll give my feedback. You tried very well, and I'm impressed. Thank you for that. You've done well. You've really tried. Now, for the issue of let's begin with the issue of ordinary and special resolutions. Now, for ordinary and special resolutions, the difference between an ordinary and a special resolution is that for you to pass an ordinary resolution, you just need a simple majority. Yeah.
Okay.
And a simple majority is basically just 51. Out of it's 51. It's a simple majority.
Okay.
For an ordinary resolution to be passed. The other type of resolution that I asked was a special resolution. And now for a special resolution, what do you need? You need 75%.
Okay.
For it to pass. That's fine, huh?
Sure. Thank you, Sana.
Okay, now just to simplify it further, for ordinary resolution, now there are circumstances where you'd use an ordinary resolution, and there are circumstances where you would use a special resolution. So, for instance, things to do, now this is how I think about it, how to simplify it. If something requires just a simple majority, it means, okay, yes, it's a serious issue, but it's not as serious as a matter that requires a resolution to be passed by a 75% majority. Yeah, and you can check the issues to do with ordinary and special resolutions, section on Companies Act, section 256 and 257 of the Companies Act. Yeah? You can check the difference between the two. So for ordinary resolution, it's a simple majority, which is basically just 51, a simple majority. But then for a special one, it requires 3/4, so which is 75%. So for instance, if you want to amend the articles of a company, articles of association of a company, you will need what will you need? You will need a special resolution to amend the articles of association of a company. Yeah. Now, for ordinary resolution, a circumstance where I can think of one is on what's it? Maybe Alex, but okay, for ordinary resolution, a circumstance will be when winding up a company. If it was provided for in the articles that the company was supposed to be wound, that the company was supposed to be wound after a specific time has lapsed, or after, or if the purpose for which a company was formed is already complete. So let's say company A was formed to complete a specific task, and that task has been done, you can pass a special resolution for the company to be wound up. So that's one circumstance where an ordinary resolution is used. So you can check the Companies Act, section 256, read together with section 257. Ordinary resolution is under section 256. A special resolution is under section 257 of the Companies Act. The other question that I had asked is with regards to the cab rank rule. So the So the cab rank rule is basically a rule, and it's in line with you interact with it in professional ethics and in trial advocacy. So the cab rank rule just basically states that an advocate must take a case that is within their knowledge. You cannot just say no to a matter. So it just means that you need to take up a case. So it began. The rule has its history in England, whereby cab rank. So whenever you approach a cab, they will just take you in. So as advocates, the rule applies to us, whereby we are required to take up a case that is within our knowledge and expertise, no matter how unpalatable a case is. So for instance, somebody maybe has murdered someone, and then they approach you in your office and they say, kindly represent me. You have to take up that case. There are certain exceptions. Now, maybe you do not have time allocation. Maybe you do not have the fees paid is not adequate. Maybe you do not have expertise in that specific area. As the saying goes, there's an exception to every general rule. But the general rule in cab rank, the general rule under the cab rank rule is that an advocate ought to take up a matter that is well within his knowledge. What was the other question I asked you? Because I thought that I took down those two questions because those are the ones that I thought need to come out more clearly. Otherwise, you've done, you've I can say a fair attempt. Thank you for that.
Thank you, Sana, Mr. Salonka.
Okay. Who else wants to volunteer? Maybe we had Muturi. I'd actually take Muturi. Ochieng. Yeah, Ochieng actually raised his hand. Ochieng, are you in? Ochieng?
Sophie?
So? Oh, yes, Sophie. Hi, how are you?
Can you hear me?
Yes, I can hear you, though a bit far, but yes, I can hear you.
Okay, before you go, the powers and director and the difference between powers and duties.
Oh, yeah, between the powers. Oh, yeah, I've remembered it. Oh, the difference between powers and duties of a director, yeah? Hello? So let me clarify on that now before we go on. So the difference between powers and a director, it's actually self-explanatory. I'll give you a few powers and then I'll give you a few duties, and then now you can contradistinguish between the two. Now the first power of a director is they have the authority to bind a company. They have the power to bind a company. On this, you can check section 34 of the Companies Act, whereby the directors enter into contracts on behalf of the company. Yeah, that's the first power of a director. The other power is the power to convene general meetings. They have the power to convene general meetings. Then you can check that under section 276 of the Companies Act. So those are two so far. The other one is power to allot shares. That is another power of a director. Section 328, read together with section 329. You can also throw in section 346. And then when you read company law, you'll come across a term known as equity securities. So equity securities are basically ordinary shares. So you can check that power. Then you can also check under section 125, power to control the voting power of a body corporate. So they control the voting under section 125 of the Companies Act. Now on to duties, you can now talk of statutory duties and common law duties. So the thing is, they incorporated the common law duties into statutory provisions. So there's no much difference, but then just to show a lecturer that you can say that they began from, these are common law duties that they arose from the common law, and they've been incorporated into the statute. So under the duties of a director, there's section 140 of the Companies Act, which provides for the general duties are based on common law principles and equitable principles. And then now kuna hizo zingine, duty to act within powers, you can check section 142 of the Companies Act. Duty to promote the success of the company, section 143. Section 144, there is the duty to exercise independent judgment. 145, duty to exercise reasonable care. Duty to avoid conflict of interest. Duty to declare interest in a proposed existing transaction. And so forth. So as actually Muturi pointed out, sometimes they intertwine, but I try to distinguish both of them. So I gave a list of powers, and then there's also the list of duties of a director. Is that okay, Wanzala? I can't hear you I can't hear you very well, so won't be able to question you very much. Okay, now since I can't hear you.
Can you hear me now?
Yes, I can hear you now.
Yes. Thank you so much. I've understood, appreciated.
So, okay, are you willing to maybe take 2, 3, actually, because time is running out. It's 10:45. Do you want to take maybe 2 questions, 3 questions?
No problem, I can attempt.
Okay, no problem. So Lavins will ask one, Alex will ask one, then I will ask one. Then now we open the session for general questions, and now we close.
Okay.
Lavins, Senior, please start.
Thank you, Senior. Sophie, how are you?
Fine, thank you. How are you?
I'm faring on well, thank you. So my question is simple. Do you have any senior advocate that you admire in this country?
Yes, I do.
Who is that?
Senior Dancer Omari.
Mm-hmm.
Yes.
Okay, so why do you admire Dunstan Omari?
I think it's because I've seen I've seen and I've read most of his cases in family law, and it is an area that I admire.
All right, that's all, Senior Solongo.
Thank you for that. Alex.
Hello, Sophie.
Hi, Alex.
How are you?
Fine, thank you. Yourself?
I'm fine, thank you.
I'm good, thank you.
Okay. My question to you would be first, just by the way, you have said you admire Dunstan Omari.
Yes,
Why
I do.
did
I can't hear you, Alex.
Sorry, why did you refer to Dunstan Omari as senior?
I refer to him as senior because he's already an advocate and he has already started practicing before me. So he's years ahead in the profession.
Okay, thank you. My question is on companies. Sorry, on commercial transactions.
Yeah.
What is the difference between a limited partnership and a limited liability partnership?
A limited
Partnership and a limited
Yes.
liability.
Limited liability partnership is where each partner takes on their own liabilities. They're not responsible for the liabilities of the company, or rather of the partnership. And the limited partnership is where the partners are held responsible for the liabilities of the company to the extent to which was allowed during their formation. To the extent to which they agreed on during their formation.
Okay, thank you so much. Solonga?
Thank you so much. Thank you so much, Sophie. So far, so good. For me, it's just a simple question. Comment on the advocate's dress order. How should you dress as an advocate?
Well, the dressing code rather.
Yeah, I mean the dressing code, advocate's dressing code. How should you dress as an advocate?
Well, I think the dressing as an advocate, I think it is in order because this is a respected profession and it's a profession that takes care of the public good. So I think when you dress, there's an image you're putting out there and someone wants to see that a person who is representing me has a certain code to which they adhere to. So there must be some order so that someone can differentiate between someone who is trying to represent them and someone who's just passing on the street. So I think it is in order. The profession needs to be regulated by rules of conduct and dressing and even speech. So I think it is in order.
Thank you for that. Now for me, you answered my question. So for Alex and Lavins, now maybe for me, you could just check the advocate's dress code. Yeah. That's all. But you have answered it very well. It was an open-ended question. I'm satisfied. Lavins and Alex can give.
Okay, thank you.
Okay, maybe I can go first.
So Alex, go on, Alex.
Okay. So Sophie, between a limited liability partnership.
Yes.
In a limited partnership,
yes,
of course, partnerships, there must be at least two persons carrying on business. At least two persons.
Yes.
So, when you look from Section 56 onwards in the Partnership Act, that is Part 3 of the Partnerships Act 2012. It talks about the limited partnerships. And this partnership is defined under Section 56 of that Act and Section 4 of that Act, that is the Partnerships Act 2012, which says that partnership is a partnership in which there is at least one person who has an limited liability, and then there's another person who has limited liability. So that's the main difference. That's the main feature about a limited partnership. There are two partners, at least two partners, but one of the partners has an unlimited. That is, their liability is not limited. But then the other partner has a limited liability. So kama walichanga 10K, the partnership is liquidated, they only lose the 10K which they changed. That's the main feature of a limited, and you see, limited partnerships are not. You cannot find a law firm which is a limited partnership. Limited partnerships are usually found in in such businesses as hedge funds. You know, hedge funds. Hedge funds are those funds which there is one fund manager who is running the show, and then there are other silent partners who just contribute the money. So the silent partners become the limited partners, and then the person running the show becomes the unlimited partner. I think if you as you read the partnership that will come across, you will understand better. There are other differences, of course. If you are asked during orals, you say the limited partnership is provided for under the Partnerships Act, but the limited liability partnerships is provided for under the Limited Liability Partnerships Act. Of course, there are so many differences, but the one that I've said is the main difference. Okay, so I hope you have understood that difference. It confuses so many people. The second question, the first question which I asked you was why you refer to Dunstan Omari as senior, and the reason I asked that question is because of the etiquette, for lack of a better word, in the legal profession. You see some things. If you are in class C and you are taught by Maloa, I think he also teaches class A. He also lectures in class A. And I'm not sure, but I'm sure he lectures class C. He'll tell you some of the things. For example, bowing before the court. You see how people bow before the court? Bowing before the court is a preserve of advocates. As an advocate, you should not bow before the court. It's just that people just bow because everyone is just to see advocates bowing and they also bow. But it's a privilege of advocates to bow before the court. Lay people or commoners or ordinary lawyers are not supposed to bow before the court. They're not expected to bow before the court. That is one. Also, secondly, the use of the word senior is a preserve of advocates. You cannot refer to a person as your senior if you are not admitted to the bar. I'm during my pupillage. I cannot refer to an admitted advocate as my senior because I'm not admitted to the bar yet. The reason I've pointed that out is because I remember there is a guy who was given a dress down on Twitter for referring to an advocate as his senior, and he was told, hey, I'm not your senior. You are a pupil, and I'm an advocate. I cannot be your senior. I become your senior when you get admitted. So I just thought I'd point that out. Thanks. But you have done well. You have tried. Thanks a lot. Lavins.
Thank you, Counsel. Mine was simple. The reason why I asked you if you had any preference to a legal personality that you admire, and you mentioned Dunstan Omari, and I asked you a follow-up question, why do you admire him? So in other words, what I wanted to test is, do you know the qualities of a good lawyer? Okay. See, in trial advocacy, a panel wouldn't ask you, directly, like, tell me the qualities of a good lawyer. No. So that scenario that I've given you, that's the formula they use. So in asking you, why do you admire Dunstan Omari, I just wanted you to know, give me the qualities. Tell me the qualities of a good lawyer. For example, punctuality, respect, hardworking, the dress code, the oratory skills, you have the research, and everything underlying. Yeah, so basically that's what I wanted to test. Do you know the qualities of a good trial lawyer? Or just basically the qualities of a good lawyer? What makes a lawyer, exceptional, okay? What distinguishes one lawyer from the other? Yeah, so that's all. Nothing to add, but good trial. Keep on keeping on. Solonke?
Thank you so much. So Wanzala did very well. Thank you so much, Lavins. Thanks so much, Alex, for coming. Now, maybe you guys can give us feedback, maybe on areas we need to improve on. Make general comments. Already 11. So, okay, it's 10:56. So for those few minutes, we'd appreciate it if you guys maybe give us some small feedback. Randomly on anything. No, alikuwa. No, you didn't raise your hand up. Okay, yeah, go on. Yeah.
Kindly allow me to thank you and Alex and Patrick. I'm just realizing that my button was muted when I was saying thank you and when I was trying to ask questions. I'm just realizing I was on mute. So I just want to thank you panelists for the feedback, and I promise to read more on it and improve. Thank you so much, Alex and Solonka and Patrick.
Asante
Yes,
sana.
you're welcome.
Welcome. Noah, your
So,
hand is. Yeah.
Give Noah Oreda a chance to.
Yes,
to ask.
maybe he wants to be asked a few questions.
Otherwise, he'll be on our next. So, Oreda.
Good evening, everyone. So, my apologies. I'm late. Well, plantation things are hard. What I would like to say to my fellow colleagues and the student, everything is a learning process. Utaamka leo ujue kesho kuna kitu mpya. Like today, I've just realized that there's an application to come on record. I've never heard of anything like that. Karibu plantation must nipigie kelele niende civil procedure rules nisome tena. So I had to go through it and I learned a new thing. So like what Solonka said, we are not geniuses. Every day we learn. So do not be afraid. Still be ready to learn. And I think me personally, as from last week, and I was telling Kina Solonka, me, I'm taking notes. There was a time, I don't know which student was asking certain questions. I had to re-strategize the type of questions I was going to ask this lot. All I can say is that I'm happy. There is future for the legal profession. My apologies, I'm late. Next time I'll be early. Mr. Pareno, I don't want to take much of your time. It's only 1 minute remaining, so I'll just end it here.
No, it's fine. No, it's fine. It's fine.
Okay.
You thought you wanted questions.
Let them ask.
No problem. Okay, if you have a question, maybe general or anything, or a clarification you may need, please go on. Or Mary, please go on, Mary.
Parano, there's a question you asked on making an oral bail application. I didn't quite get it. Maybe you can do it again, please.
Oh, the question I asked, it was I can't remember his name very well. But yeah, so the question, what I was just testing is his confidence. There is really generally no particular way of doing it. You just need to when the lecturer asks you that question, you just need to introduce yourself. May it please this court. My name is Mary Neno, appearing for the accused person, and I would like to, make my apply for bail on behalf of the accused person. Now, in that particular question, what will be tested is if you know the bail and bond policy guidelines. So what are some of the conditions that need to, what are some of the issues that will make someone not be granted bail? So you have to talk about flight risk, which you raised very well, the seriousness of the offense, he's a first-time offender, and so forth. Then always remember at the back of the mind that it's the prosecution side which has to prove that this person has a flight risk and is not deserving of bail. Is not deserving of what? Is not deserving of bail. Then now also, or maybe that's the thing that he didn't mention, you can also throw in the Constitution of Kenya, that the accused person has a right to bail pursuant to, what article is it? Article 14, Article 49 of the Constitution. Article 49 Article 49H, if I'm not wrong, of the Constitution that provides for being released on bail. So that's all I just required from him. Well, may it please this honorable court, my name is Bareno Solonka, appearing for the accused person. In line with Article 49H of the Constitution, I present or I make an application for bail on behalf of the accused person. It should be on record in this honorable, it is on record in this honorable court that the accused person is a first-time offender, he's not a flight risk, and pursuant to the Constitution, all offences are bailable, and we humbly pray that this honorable court releases the accused person on reasonable terms and conditions. And you can even talk about the fact, just kurembesha and to impress that, bail can be issues to do with free bail. You can be actually out on free bail. You don't even need to deposit any sum of money, because the primary consideration of bail is to secure the attendance of the accused person. So if you can show that this person will attend court, even be granted free bail. That's all I required.
Yeah.
Okay, Karim. Edan, I can see you.
Thank you very much.
Yeah.
And your colleague, Patrick, and the others. Thank you very much for creating us this time. My question is with regard to when you are being asked a specific question, you have to maybe you have the problem of quoting a specific law. For example, the issue of injunction. They are provided under Order 40 of the Civil Procedure Rules. So what if you don't remember that particular law? Can you just say the Civil Procedure Rules and this without even quoting the specific section or of the law? Because these things are very many, and maybe it is hard to remember the specific sections. So what if we just say they are provided under this law? Maybe is that the correct way to go? That was my question. Thank you.
Thank you so much, Edan. Yeah, you can do that. You can do that. You need to understand that even when these people go to court, you see them having, you'll be making submissions, but they have documents that they're referring to. They have statutes, they have the Constitution. Every advocate, every lawyer, every judge, every legal practitioner in this country usually refers. So you should remember that at the back, you should always remember at the back of your mind that nobody knows all these provisions in mind. Yes, you may know a few, but you do not know all. So if you're not sure the particular section, you can just mention the statute, the umbrella statute. So for example, it's an injunction and you can't remember Order 40. You can just go on ahead and say the Civil Procedure Rules. You asked on revision, it's under section 162, go onwards. You can't remember the statute, the section very well. You can mention that it's provided for under the Criminal Procedure Code. You can talk about, you've been asked a question on review, you can't remember Order 45. What do? You can mention the Civil Procedure Rules. You've been asked about donatio mortis causa. It's section, that's probably, you see, I can't even remember donation. I don't know if it's 32 or 31 or again, but it's equal to hapu. Yeah. So you just mentioned the Law of Succession Act. Yeah. How can I say? The issues to do with what? Maybe Constitution. You can't remember. Maybe you've been asked something pertaining to interpretation of the Constitution. Yeah. And you can't remember section 260. Just mention that the Constitution provides for, how will you interpret certain words in the Constitution, and so forth. The meanings, the definitions that are found in the Constitution. So you don't have to remember. Okay, it's good if you can remember. It will show the lecturer that this person knows his stuff, as Alex puts it. Yeah? But if you don't remember, you can just mention the statute and then move forward. That's the advice you can give. But if you can remember and you know you can and you're confident, go on ahead and give it.
Okay, thank you very much.
Karibu sana. Wanjala, please go on.
Solonka.
Yeah.
My question is the question that was asked earlier, I think by Patrick. Mm-hmm. So this person refuses to take plea, and it is deferred to a later date. And that later date, the person still refuses to take plea because they are exercising their right to silence.
Yeah.
So now what happens? Because you can't, I don't think the court can keep on deferring the plea, even if they defer it, it can be maybe 2 times. Now, other instances where the person completely does not take the plea, and how is that handled? Does the case go on as presuming the person, of course, there's a presumption of innocence. So does the case just proceed on the basis that the person is not guilty, so that the burden of proof still rests on the prosecution? So that because the litigation must come to an end, and the person is not taking plea, they have simply refused to talk. So what happens in that instance? Can the case proceed, or what happens?
Lavins, do you mind taking that? It was your bit. Maybe I can contribute something small to it.
Alex, okay, you can just proceed. I'll come after you.
Okay. From my knowledge, you see, there's the issue of unequivocal plea. So let's say, for example, you have been asked to take plea before the court. You could say it's either guilty, you say kubali mashtaka, or you say not guilty. Anything which is not unequivocal plea cannot be entered as a plea of guilty. So the court usually has, from my reading, they enter a plea of not guilty. If you decide to keep quiet, they will enter a plea of not guilty, and then the prosecution will be called upon to make its case. Then after that, if you don't defend yourself, of course, and the prima facie case and section 10, the court will proceed to convict you, litigation. Maybe Lavins can.
Okay. Yeah. Thank you, Alex. Not much to add, but at the end of the day, Article 48 and Article 50, sub-Article 4, they have to be sort of adhered to. At the end of the day, you have to ensure, did this court give a fair hearing? Did the rights of an accused person, were they factored in? So deferment of plea doesn't necessarily mean that the accused person may not how can I put it, may not necessarily take the plea. See, at the end of the day, justice, the arc of justice has to bend. And so at the end of the day, there are victims in this particular case. So for the interest of justice and with the court's discretion, then the court will have to provide the guidance it deems fair, just, and expedient to dispose of with the matter. And also, an equivocal plea is always taken into consideration. Silence may mean that the person is not guilty. So you are not guilty. So after the prosecution presents their case, close of the prosecution case, the defense takes charge. Yeah. So at the end of the day, for the interest of justice, it is the court to weigh upon itself to determine if the matter should proceed with or in accordance with its guidance, but at the same time, they have to ensure that Article 48 and Article 50 sub Article 4 are not really violated, because the accused has his own right as well. Okay, yeah, so that's why we have those types of pleas to match in accordance with the case-to-case basis, but are consistent. Someone may not really defer. I have never heard of a case where deferment is taken even more than twice. Yeah, so it depends. Yeah, okay, because maybe the mental assessment has to take place. You can't take plea when you're not mentally okay. You understand? Yeah, so there are just differs with circumstances and the factors that the court may deem fit to look at before considering whether the matter should be dispensed with. Yeah, that's it.
Thank you for that, Lavins. Thank you for that, Lavins.
Okay,
Now,
thank you.
Wanjala, now maybe just even to, okay, they've just answered, they've answered everything that I wanted to say. But when you talk about plea of not guilty, okay, let's talk about two things: plea of guilty or plea of not guilty. There are certain conditions that need to be met when you're pleading guilty. You can check the case of Vardan by the Republic. Now, on the other issue of plea of not guilty, it's entered in three instances. Where, and one of them is if you refuse to plead. So if you refuse to plead, a plea of not guilty will be entered. And you can check section 280 of the CPC, of the Criminal Procedure Code, read together in section 207 of the CPC. You can check those. I can check those particular provisions. So plea of not guilty is entered where you refuse to plead, where you do not admit to the statement of facts. So let's say you had initially pleaded guilty, and then the facts are being read to you and the evidence, and then you say, like you say, okay, nakubaliana na hiyo, lakini, I agree with you, but a plea of not guilty will be entered. And then where you expressly don't admit to the charge, a plea of guilty will also not be entered. So that's how it will apply in that circumstance, or how it will unfold in that circumstance. Since, okay, karibu sana. Do you have anything else so that we can close up? Okay, now since we've come to the end of the meeting, I appreciate you guys for coming. Godspeed. If you had texted me and I had not replied, feel free to retext. I got overwhelmed, and it's not that I'm ignoring. It's just that maybe I got held up a bit and I forgot, and it slipped my mind. I get a lot of messages during the day and it may have slipped me. It's even better if you call me, because when you call, we just solve it there and then. So feel free to retext. We're always here. Labians is there, Noah is there, Alex, Kinasumaya, everyone is there. So feel free. We're here for you, and we're here to help you pass. All the best. And then also remember to kindly, please, if you're able, kindly subscribe to the YouTube channel. I'll send the video. I'll send today's mockups tomorrow. So kindly subscribe. There's a particular thing that I'm doing, a particular project, and I will rely on those links to do the paper, to do that particular paper I'm doing, and a particular application. So kindly assist in that. I appreciate it. Have a good night. See you guys. Oh, and then sorry, before I forget, I also remember that we are supposed to add another what? We'll add another. We'll talk with my colleagues and we'll try to see if we can schedule some more time to maybe accommodate. You guys had raised an issue that you want us to add more time, so we'll try and see if it's possible. Then I'll try to. So have a good night, guys.
Good night.
Good night.
Good night, guys. See you.
Good night.
Good night.
Thank you so much. Good night.
Awesome. See you.
Thank you so much.